You're rocking with the best. You're rocking with the best. You're rocking with the best. You're rocking with the best.
Scarcity and financial projection. This plagues these spaces daily, because when someone has been for or believed that they've been for, because I'm gonna address that for a second. I think a lot of people play a bigger role in them being more than the teacher I believe that many people were already setting themselves up to fail by hearing what they wanted to hear and fall into the trap of the person that's doing this telling you what you want to hear.
Welcome to this live stream from the New Culture Empire. Today, we will ask the question, is a consumer contract viewed only by consumer terms, or does a consumer contract have multiple lenses in which it is viewed? As a bonus, you will get a behind-the-scenes look into Class 1 of the Supreme Elite Team University. You still have time to enroll and become a part of a consumer movement that transcends the traditional consumer arguments. Don't miss out on this great opportunity to learn like a professional.
You're rocking with the best.
We step through all switch when the foul won't see the net move. No more dating, got the title that's flex move. Now your next move, make sure it be your best move. Supreme Elite Team University. Thomas teach the code. That's the key to me. He self-taught, but he made it look so easily. Easy, he stood with an attitude like easy, he done makes you your best move. Matter of fact, said you should be your next move. Next, self-taught, but he made it look so easily. Easy, he still with an attitude like easy. They still in hard with the finest chart. On God, don't make a payment, they don't care, they just write it off. Gone, but it's who cause of the kind.
Most people are going to look at their contract. They think that like say in an auto, of which we're going over here, they think that the finance company actually, let's say the sticker price is $25,000. They actually think the finance company actually paid the dealership that $25,000 for them. They think that, but we all know what happens. Like, they really believe that they're dishing out that type of, they're not dishing that out. Man, it's pennies. This provide, before you even, they even send you a default or notice of intent to sell your vehicle. Like, my gosh, but it's already happened on the books. My gosh, but this is where you see these people focusing on who has the right to enforce. You're not the lien holder. You can't be doing this. Or they'll be like, if Carvana gave Century Auto the right to service and allow them to repossess, they'll be calling Century Auto like, hey, you're not the one I didn't get the loan from you. You never gave me any. Do y'all see what we're reading right here? Can y'all see how this makes a difference in our arguments? Can't y'all see how this makes a difference in our arguments? Like, you wouldn't even care who's servicing the contract. It doesn't even matter. Because SETU, y'all, we get into the meat and potatoes. This is something that they don't want to disclose. And we know it. Now, y'all can actually see what the finance charge actually consists of. You see that? These are the items, all the items of what's the finance charge. But see what they book it as? You see what they book it as? So when you look at your finance charge on your contract and then you understand this and come here, you'll realize everything you paying in the finance charge ain't nothing but fees and stuff being passed on to you. The problem with many people out here, y'all, is they can't prove what the finance charge actually consists of. They don't know because they use these highly technical accounting terms. Let me look at that right here. And if you look here, this is how they're jacking up the price of the vehicle. You see that? Look, included in the principal balance. See? All that extra stuff, all those extra stuff that you're getting is being jacked and built into the purchase price of the vehicle. 50% of people's purchase price of their vehicles is all fees and behind the scenes stuff that they just passing on to you. But they can't pass it directly on to you because it will violate TILA. So how they get around TILA is they'll put all those fees in the purchase price of the vehicle. Now, can't get around it. That's how much the vehicle costs now. That's how they get around TILA. That's how they get around TILA. The only way you can stick them on a TILA claim is if you know this right here. Bam! Because none of this is disclosed on TILA. That's how you get them. This is how I got credit acceptance. Y'all get an inside view on how I stuck it to them. And notice how they had to settle. Where's it gonna say, this is not true. This is how you get them. When we get to the court side to SETU, this is how you get them in court. And you won't waste your time with these frivolous, who cares, doesn't matter type arguments that you see people make online all day, every day. Because with them, they don't understand that the consumer takes on this consumer contract takes on 5 different things, 5 different views of it. People think that the finance company views the contract just off the obligation that they owe. As we went over earlier, the finance company don't even view the contract based on the total of payments, the amount financed, and what you got to pay back. They don't even care about that. They don't care. They don't view it like that. Remember, you got the consumer side, which everybody views the contract. You got the court side, how the court views the contract. You got the corporate finance side, how they view the contract. Then you got the regulatory side, how they view the contract. Then you got the investor side, how they view the contract. If you don't know the corporate finance, regulatory, and investor side, you are going to put yourself at a deficit just trying to argue these contracts based on the consumer side. Knowing the other 4 actually puts you in a position to lead to settlements. They don't want to talk about it. They don't want to get into an argument with you over this when you got them dead to rights. You don't have them dead to rights by just keep trying to argue consumer. And this is why the SETU right now is so important, because y'all getting the other 4 views of the contracts, which they will never tell you. You will never know it's there. I can take one contract and explain it in 5 different ways, and which we're going to do in these classes. I'm going to break down the contract and explain to you what it means, 5 different views, because unless you know all those 5 things, you're never going to fully understand your contract. And this is going to lead to frustration for a lot of people out there, because they think they're citing all the consumer laws, but the courts know they don't know the other side. The finance company knows they don't know the other side. And this is why they'll send in all these documents, but their vehicles are still being repossessed and their homes are still being foreclosed on, because they don't understand the game from a corporate professional level. And this is what SETU brings.
See the gavel anywhere, yeah. Thomas with the knowledge, calling Dr. Seuss. Yeah, I know what it is. Be coming with these packages. Secret accounts like they had a right to pursue that BS. Now knowing that theory came from Roger Elvis, it was all a myth. Now look at them. So desperate, they like flies on. Every free money without understanding, and they jumped on it.
You're rocking with the
Embarrassed,
best.
they fell for the okie doke. Now they don't want to admit they got taken to the bank because of their own desperation and greed. Facts. Now they want to hurry up and do another process to cover that. Embarrassment up, nah, I see you. Can't pay your bills, now you want to create instruments with nothing backing it. Think of that secret account.
You're rocking with the best.
Where the millions at? Where the mansions at? Where the assets at? Nowhere to be found, nowhere in sight, but y'all wanna get mad at me.
You're rocking with the best.
You winning. All self-talk, professionals on my team, that's a fact. Y'all heard the phone call, so I played a major role in my own settlement. Legendary.
You're
But y'all
rocking
still
with
talking
the
trust and
best.
call. Let me see the wet ink signature. And all that garbage, get your cars repossessed. And you wanna blame the system like it's a conspiracy. What they always say, oh yeah, and I want the truth out, nah, that ain't it. You just had no foundation, you're mentally lazy, and don't wanna accept the fact that you fell for the sovereign citizen trap. Come to set you, we will deliver you.
You're rocking with the best.
We will deliver you from the struggle processes. You won't have to tender a check just cause you can't afford or don't wanna pay a bill. You'll be like me. That entitled back to your friend live.
You're rocking with the best. 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 You're rocking with the best.
Back in the building with another one. We are back, as you can see. We kick back, man. We laid back today. It's gonna be a chill stream. It's gonna be a laid back stream. We just in the cut, man. We in the cut. We in the cut. We got class part. Tell me today's Monday. Yes. Ooh, thank God. We got class 2 of the Supreme Elite Team University. Class 2, night 1 was a major banger for my WWE fans. It was a banger. And if you look on the screen, 5 lenses of the consumer contract. The 5 lenses. Now, as you seen in the intro, that little sneak peek video, that was actually the end of SETU, end of night 1, end of the class. And one of the things that, and I was talking about this on TikTok yesterday, one of the things that I can only wish that people would understand is that our consumer contracts actually has 4 other lenses to them. Consumer laws are like this. I want everybody to be skeptical about any agency, government, corporation, any agency that has its own like grievance policies. That's what the consumer laws in TILA is like. All right, y'all, this is what you argue if you have disputes with your consumer contract. I want you consumers, y'all stay down here with it. Don't go try to argue your case like a class action lawsuit. You're going to kick up too much dust. So if they violate TILA, don't disclose the true cost of credit, violate the FDCPA, yeah, y'all go ahead and bring those claims. Yeah, y'all could do that. Because if they robocall you, if you tell them to take you off the list and they continue to call, you can actually sue them for that and you could be awarded damages. But there's more behind that door. There's more behind that door. And what SETU does is we don't just argue from the consumer standpoint, because your consumer claims does not tell the full picture. And when you argue consumer claims in court, The judge, now the court side, the number one thing they're going to look at is, was this contract legitimate from the beginning? Now, people will make arguments stating that, oh, they didn't loan me anything. They didn't loan me anything at all. Uh, they didn't loan me anything at all. They didn't loan me anything. They didn't do any of that. You know, and the question about those arguments is, what if the statute states that the creditor or lender includes third parties? What if the statute's interpreted that the lender didn't actually have to physically lend you anything if they were working on behalf of the people who actually lent you the money? What if the statutes are interpreted to mean that? What if it doesn't matter if Bank of America didn't actually put cash in your hands or they supplied it? What if they're still the lender if they originated it? See, this is the corporate side of how things work. What if the original lender, the originator, what if they're viewed as the creditor, in which they can assign their security interests to a third party? What if that's perfectly legal from a court standpoint, and a corporate standpoint, and a regulatory standpoint? What if that's perfectly legal? So if that's legal from a corporate standpoint, court standpoint, and regulatory standpoint, now let's look at that argument from the consumer side again. Prove that you loaned me anything. You see how these arguments start to fall apart? Because notice, everybody's online saying, prove that you loan me this. Prove. You can't prove. But what they're not showing is free and clear titles based on the merits of their claims. You notice they're never showing that it's actually accepted in court. Rather, those arguments have been foreclosed by many court rulings. Prove that you owe me the money is a spinoff. Prove that you loan me the money is a spinoff from the 1990s argument, which is called the vapor money theory. It's the vapor money theory spinoff. Okay? It's a vapor money theory spinoff. And since I know what I talk about gets to a lot of people's belief systems, since I know a lot of things that I speak, many people are going to shoot it down because it's just coming from me. But as I always like to say, if you don't want to hear from me, I'll let the judge tell you. If you don't want to hear from me, I'll let the judge tell you. And why did I use that approach? Because it lets everybody know, for one, I'm on par with the courts. I'm on par with the courts. I'm on par with the corporations. I'm on par with the professionals. We're on par. We are on the same page when it comes to how to argue, how to defend. Me, the courts, the corporations, the regulators, and the investors, we're all on the same page. We gotta understand it. We got to understand it. And yes, I am an agent. I'm an agent, y'all. I work with the inside professionals. I'm an agent of the truth. I'm an agent of the understanding. I'm an agent of stepping into a corporate world and planting my flag, planting the SETU flag. So, without further ado, let me show you exactly how these vapor money theories hold on. So they got two let's see. Okay. So they got two cases. You got Ephraim Demons versus the Department of Veteran Affairs. And then you got Salam versus Movement Mortgage PDF. Let's do the Salam versus Movement Mortgage LLC. Actually, if I can just, there we go. Now, one of the things that I teach everyone with the SETU is we have our facts and evidence. The other side has their version of events. We have our version of events. But what people don't understand is, and what they actually hate to hear, is that your facts in the events, there's always going to be the legal standard applied to it. So I can tell the courts whatever I think happened, but they're going to look at your claims and apply a legal standard. I mean, there's going to be a set of guidelines and a set of that you're going to have to pass in order for you to be past the standards. Now, give me a second. Give me 1 second. I forgot to add them in. 1 second. TikTok. What's TikTok? Oh, hold on. 1 second. TikTok. Oh, shit. TikTok. All right, there we go. All right, TikTok. What's going on, man? We are live on the New Culture Empire. We are Liggity, live. All right. So, get my body armor. I gotta keep the armor on. Because y'all know it gets spooky around these parts of town. Y'all know it gets spooky. They would love, like, I swear to God, before I continue, they would have loved. Man, I think my fan is too. Hold on, it might be picking up too much. Yeah, it is. Give me 1 second, because I don't want it to interrupt the playback. Give me 1 second. Then we're gonna get into this case. See, how does that? I guess. I hope it's not too much. I don't see any back. I don't see any Okay, I think we good. All right, so annual alam versus money movement mortgage. And hey, y'all, let me say this. You know what the real problem is? I'm just such a dream killer. Like everything they think is the truth, I just crush them. I just crush their dreams. I'm a dream killer. I am. I'm the Grim Reaper. And I've learned to embrace that role. I'm the dream killer. Whatever you think is the right way, you best believe you better come correct. Because I'm going to let you know it's not. If it's not. If it is, kudos to you. I won't say nothing. You got it. This matters before the court on defendant Movement Mortgage LLC's motion to dismiss. Of course. The court has carefully considered this motion in the parties' briefs and supported opposition on the motion. Simply put, as explained in detail in defendant's memorandum and summarized briefly below, this is a frivolous action in which plaintiffs asserts claims that have no merit and have been routinely rejected by numerous courts. Remember when I said there, show me that you loaned me money is a spinoff of the vapor money theory, which courts have routinely rejected? This is what I mean. What these people was never expecting is for someone like me to have done more research into the things that they believe more than they have. Like done more research and more in-depth investigations into what they believe more than the person that believes it has. This is why it's a news a shock to many people when I told them that your secret account at the Treasury based on your birth certificate and your social security number was created by a man named Roger Elvick. It was never HJR. It was another individual that created it. And he had a big name in these movements in the 80s. And then it spread like wildfire. And then when he got sentenced, did his time in prison, he came to admit that the secret account doesn't exist. The Treasury account doesn't exist. Why is this secret Treasury account so important? The secret Treasury account is so important because hundreds of processes have spawned from that. The negotiable instruments, the tax filings, the tax returns, the instruments to pay your mortgage, all that stem from the belief that there's an account somewhere out in the stratosphere inside the Treasury that if you send this stuff to the Treasury is going to wipe the debt away. Or if you send it to the bank or the mortgage company and they send it to the Treasury is going to wipe his debt away. Roger Elvick created the whole Treasury process where you get a copy of your birth certificate, then you get a copy of your social security, you file a UCC1, you get your bill of exchange. Back then, they would use the site drafts or your site draft or whatever instrument. You get your private register indemnity bond. You get that bond. And they said by doing that, you're charging up the account. So the account was dormant until you charge it up. So you present them with a debt, and then they're going to offset the debt from your account and send the funds. That was created by Roger Elvick. Now, the Moors and the African Americans who bit into this, it's evident that none of them understood the origins of what they believed, because the same people they were following were the same people that would have scalped them and burnt them at the stake if they had the opportunity to do so. Meaning, you was dealing with a white supremacist. So we got so many African Americans following a white supremacist who never intended on African Americans to even, it was never for them. But you got so many African Americans today still sending out negotiable instruments thinking there's an account or the check payable to the Treasury. And these people, they don't even understand the origins of what they believe in. They don't even understand the origins of what they believe in. That's the sad part. And listen, you can do whatever you want. All I'm saying is, I'm trying to help you. I really am. The trust fund treasury account was created by Roger Elvick. He just had a major name. And then all these subset groups, when they feel like they can make money off it, they just put their own spin on it. But the secret treasury account started from a man named Roger Elvick, Elvick. He is the spearhead of that movement. He had a big hand and he influenced the redemption manual. He influenced it. A lot of groups looked up to him. Roger Elvick was connected to Terry Nichols. Terry Nichols was connected to Timothy McVeigh. These were extremist sovereign citizen groups from the late 80s and the early 90s that were pushing these same paperwork. Once again, the whole everything in court is a trust. You're there. They're not locking you up. They're locking the trust. And you come there for full settlement and closure of the account. And you endorse the charger instrument and send it back to the courts for full settlement and closure of the account. Okay, that right there, that became real popular in the early 2000s. And Gene Keating was one of the spearheaded movements of that patriot movement. But a lot of these patriot movements, Patrick Devines, Gene Keating, Roger Elvix, they all had ties to white supremacist groups, extremist groups. This is why the Waco, the situation with the ATF and the FBI with that community in Waco, Texas in 1993, right there was how the original sovereign citizens moved. And they are labeled as extremist domestic terrorists, the sovereign citizen groups. So what I'm saying is, you don't have to believe in the name. You don't have to even prescribe to the ideologies. For one, you could just be, hey, I'm just trying to, get out this debt. You probably don't believe in all that stuff. But when I'm telling you how the government and the courts look at it, they're going to put you in that category. They're going to put you in that category. And you don't want to be put into that category. The RRA of 1998 made drastic changes to the IRS processing and their rules and regulations and put IRS agents more accountable because Congress got tired of violating so many people's rights. So part of that act, the RAA, the IRS, they were not allowed to view certain individuals as tax protesters based on their filings, because when you were viewed as a tax protester, the government and the IRS will prejudice you. They would take more aggressive actions against you. They were more liable to prosecute you if you were labeled as a tax protester in their internal classification system. So now this is why you don't see as many IRS prosecutions and FBI prosecutions like they were doing in the 90s and the early 2000s. You will get a prosecution, and it's a discretionary. If you get an erroneous check from them and they ask for it back and you don't send it back, or if you start teaching other people to file frivolous tax returns and commit tax fraud, then yeah, they're going to go after the teacher. They don't necessarily prosecute the students because they're more of the considered a victim. Just like a woman who's in prostitution and they arrest their pimps and he gets charged federally, they don't really arrest her because she's considered the victim unless she was scheduling the calls or was like the madam. That's the only way she'll get locked up. So since they're not allowed to view people who have disagrees with the IRS laws as tax protesters, they become more lax and they won't necessarily come after you unless you give them a reason to. But all this stuff, even this court case, all stem from the early sovereign citizen movement. One second. It all stemmed from it. It's all a variation of it. And what I'm trying to tell you all is, I know a lot of you have not done your in-depth research before you started filing the documents and doing the things you do. So you don't really have an understanding of what you're actually getting yourself into and how much damage you could potentially be putting yourself into, and how much that you can actually be putting yourself further behind the 8 ball than what you think this process is going to get you out of. It's awareness. I'm not, and This is why the Supreme Elite Team University is so important, because it turns the hopeless into confidence. Because when you think you don't have enough hope, when you think you don't have any other alternatives, with SETU, you have many alternatives, and it's legally recognized, and it's hundreds of case laws to back it up, and black and white factual evidence, everything that could be proved in court. If you need an example of understanding, all you have to do is follow my credit acceptance case. It's on my channel on here on YouTube. Follow the case. Join the Supreme Elite Team group. Join SETU. You can do whatever. All the receipts that you need to see are there. All the receipts that you need to see are there. You don't need to see the title because y'all have already seen the title. You don't need to see the account zero because y'all have already seen it. It's on TikTok, it's on YouTube. Y'all have already seen it. Everything is transparent here. There's no hiding the not so good parts and only showing you the good parts. But if I'm consistently having receipts to show, then that means I must be doing something right. And just because what I'm doing may not be the same way as everybody else does, it doesn't necessarily invalidate what I'm doing. And I tell y'all, the only way that you can measure this stuff, y'all, is you got to put it under the judicial light. You can't bypass what the courts are saying about this stuff. You can't bypass it. You got to measure this stuff, measure what these teachers saying on the judicial light. Yes, ask them, have you been successful? Can you show me case law that supports what you said? Can you prove this in court? Okay, I hear what you're saying. How do I argue this in court within the court rules and regulations? If they can't answer those questions in a clear and convincing manner with actual case law to back it up, you run far away from them. Don't take a chance. Don't take a chance. Now, the court has carefully considered this motion in the parties' briefs and in support to the in opposition to the motion. We're over here on YouTube at the New Culture Empire. TikTok, this is my main battleground over here. YouTube, it's like I was telling y'all yesterday, a lot of these gurus won't be able to survive on YouTube because there's so many fact checkers over here on YouTube. They'll find themselves on Team Skeptics or Sovereign Citizen Chronicles in a minute. That's why they hide out over there on TikTok. They don't want to come over YouTube to stand up under this scrutiny. Now, simply put, as explained in detail in defendant's memoranda and summarized briefly below, this is a frivolous action in which plaintiff, and his name is Anwar Alam, asserts claims that have no merit and have been routinely rejected by numerous courts. Therefore, the court will grant the motion and dismiss plaintiff's claims with prejudice. The legal standard when you are going into court, it doesn't matter what you say is facts. The courts are going to apply their legal standard to it. And if your facts and your presentments does not pass the legal scrutiny of the courts, it will be dismissed under either Rule 8A, Rule 9B, if you're claiming fraud, or 28 USC Section 1915, if you're filing in forma pauperis. If you're filing a lawsuit, if you want to bypass the original screening, which is a strict screening, you need to pay the filing fee. Look at all these gurus filing in forma pauperis. Pay the filing fee. You bypass the screening. Under Federal Rules of Civil Procedure 8A subsection 2, a complaint must contain a short and plain statement of the claim showing that the pleader is entitled to relief. So you must, a short and plain statement. Basically, it's saying, why are you entitled to relief? Now, look at the arguments that you see online. None of those arguments are even in line with the court rules. So by a matter of law, as a matter of law, the claims are going to be rejected. Not even worry about the merits. And that's what I'm saying. What we feel happens and take place in our arguments, they are still governed by the court rules. So we got to make sure our complaints, our arguments are in confines with the court rules and procedure. And please, by God, please do not make an argument that's already been rejected numerous of times. You're going to be foreclosed as a matter of law. And this is simple court procedure 101. However, Rule 8A2 still requires a showing rather than a blanket assertion of entitlement to relief. And this is from the Bell Atlantic versus Twombly case, the landmark Supreme Court case that shows you what you need to do to pass the court sufficiency test. So if you're making a vapor money theory argument or stating that, hey, they never lent me no money, and the courts have already ruled that that is a frivolous argument, your argument's not going to be treated any different. We got to stop thinking that, oh, 50,000 people did it before me. Well, mine's going to work. No, it's not. It's just not. A motion to dismiss under Federal Rule Civil Procedure Rule 12b-6 for failure to state a claim upon which relief can be granted tests whether the complaint is legally and factually sufficient. Rule 12b-6, as mentioned in Ashcroft versus Ekbal in Bell Atlantic versus Twombly, aka the court sufficiency test. And the only way that you're going to pass the court sufficiency test, or you got an indicator that you passed it, is when they make the other side respond. Or when the other side responds, they don't immediately file a motion to dismiss, which a lot of your gurus, that's what happens to them when they file lawsuits on behalf of their clients. The finance company don't even respond to the complaint. They immediately move for a motion to dismiss or summary judgment. Not over here at the SETU. Every case I've been involved in 2025 is still ongoing. It's besides my case, that's settled. But all my clients' case ain't no dismissals yet. It's still ongoing. And why is it still ongoing? Because unfortunately, they're the defendants. You know me, I'm a plaintiff type of guy. I tell everybody, be the plaintiff. You could choose the venue. You can bring all the claims that you want. When you're the defendant, you kind of got to defend. And you can't tackle any issues that's not really on the table. This is why, like April or June on TikTok, she filed in October that she had the case remanded to the federal court in her client's mortgage foreclosure. But the problem with that is the plaintiff, which is the finance company, they filed the foreclosure in state case. So there's no federal law that's actually mentioned in pleading in their complaint. So this is why we're now in February and she never posts any updates of what's going on in the case. You want to know why? Because the courts remanded it back to the state. Now, let's see if her securitization arguments work. And since we're in February and the federal courts move at rocket docket, I guarantee that the other side has won on summary judgment, or her defenses will rule frivolous, but she's probably on appeal right now, but she'll never come to TikTok and let her fans and her followers know what's really going on. Of course they won't. They never do. In evaluating whether a claim is stated, the court accepts all well-pled facts as true and construes these facts in the light most favorable to the plaintiff, but does not consider legal conclusions, elements of a cause of actions, or bare assertions devoid of further factual enhancement, unwarranted inferences, unreasonable conclusions, or arguments. Those are how your typical social media teacher argues a complaint. Right there. The same manner what the court said you can't do, that's exactly how they argue. Want to know why? Because I read a lot of their cases. See, they think that just because they block off their plaintiff's information, their client's informations, when they post the documents, their motions on file, they have it all blocked out. But once again, I have an elite litigation model that I can still take a picture of that same complaint and match it up with the words and look in the district and file it. This is why I be calling these gurus out, because they're not thinking that anyone knows how to get the actual case, because they think if they block out the information, no one will actually see what's going on. But I done pulled a lot of their coattails on it. And this is why with quite a few of them, they take those videos down. I am the Grim Reaper of these spaces. I'm your fact checker's fact checker. And above all, believe it or not, I am your teacher's teacher.
You're rocking with the best.
I am your teacher's teacher. Don't forget that. Construing the facts in this manner, a complaint must only contain sufficient factual matter accepted as true to state a claim to which relief that is plausible on its face, meaning it's possible it went down the way Tom is saying it went down. Oh, the exhibits and the evidence, the foundation laid. It's plausible that this actually went down this way. It's plausible that he may be entitled to relief. Hey, credit acceptors, you got to respond to this. Thus, a motion to dismiss under Rule 12b-6 determines only whether a claim is stated. It does not resolve contests surrounding the facts, the merits of a claim, or the applicability of defenses. So it's basically saying that's even worse for these gurus. It's basically saying, with all the ramblings that you're doing in your court, with all the ramblings that you did, with all the legal conclusions that you came up with all the fraud assertions, they committed fraud without understanding the 5 elements, the who, what, when, where, how, which is a extremely high standard to meet, which when you even say the word fraud, you are subjecting yourself to a heightened pleading standard at that. And the judges get real strict when you start using the word fraud, especially with these finance and these mortgage companies. When their cases are getting dismissed, it's because besides all those ramblings, all that babbling they're doing, all that pseudo-legal jargon that they're doing, they still haven't stated a claim under the legal elements of law. So as a matter of law, they have not even stated a claim. And this is where Rule 12b-6 motions are filed. The other side will never file a Rule 12b-6 motion just because they don't want the truth to get out, or it's a conspiracy, or they don't want the reality. They never file a Rule 12b-6 just because they know. When they file, don't let them gaslight y'all. When they were getting these Rule 12b-6, it's because they have not stated a claim of punch relief could be granted. And since their lawsuit is in conjunction with everything they teach online, then by default, as a matter of law, everything they're teaching online is wrong.
You're rocking with the best. You're rocking with the best.
And that is when you start putting these people's claims up under the judicial light. Oh, the picture's going to get clear, y'all. They're taking advantage of you because they know y'all don't know what they know. Or you believe what that person is teaching. See, once you believe something, you let your guards down. Once you start believing it's true, there's no more reason for you to fact check it any longer. You let your guards down. I'm telling you, keep your guards up, regardless of how good it sounds. According to the complaint, plaintiff Alam executed a promissory note dated August 13, 2021 in exchange for a loan from Movement in the original principal amount of $373,000. Now, 3 years after the loan was made, Alam asserts that his loan was the result of fraud. The loan agreement constituted an alleged unconscionable contract, another word they use every day online. And the Movement is attempting to convert the real property that secures the loan. Now, once again, when you are already in default, because that's all that's taking place here. These arguments never come up when you are current on your loan. These arguments never come up as soon as you made your payment. You are not bringing these arguments up, and the courts are seeing through it. If you are not bringing these arguments up first while you're current, they're going to look at it as you're just trying to raise these arguments to get out of your default. That's how they look at it. That's just what it is. State, federal, local, they're not going to invalidate the contract just because you allege fraud after you're already in default. And this is why I'm a preacher of being the plaintiff rather than waiting to be sued. TikTok, hey, if you're being sued, go to the next channel. Oh, if you're being sued, next channel. Oh, if you're being sued, oh, if you're being sued for a credit card. Oh, if your mortgage company is suing you, that's all they have for you. They never have for you. Now, we're going to be the plaintiff. We're going to be the plaintiff. We're going to take it to, oh, you already current? All right, we filed a lawsuit against them while you current. See, they ain't got no use for this stuff when they're current. And this goes to show intent. But I don't know what I'm talking about. I've only achieved what many of people in these spaces are still trying to achieve today. Nah, I don't know what I'm talking about, though. He seeks an order requiring movement to disgorge and permit him to recoup purportedly wrongful gains. The alleged grounds in which Alam bases his effort to avoid paying his mortgage loan. Right there. The alleged grounds on which Alam bases his efforts to avoid paying his mortgage loans are often referred to as the, what did I just say at the beginning of this stream? The vapor money theory.
You're rocking with the best.
What did I say?
You're rocking with the best.
What did I say? And what they don't understand is the vapor money theory is a old sovereign. See, sovereign citizens act like they know about the financial system. As a matter of fact, they think there's a separate secret financial system that's going on. And in actuality, it's not. It's the same financial system that has been spinning on its own axis for the last 50 years. Yeah, there's been amendments, there've been upgrades, but it's all basically the same. So the vapor money theory is that modern money mechanics stuff that people still citing online. Is basically saying is they took your application, took your promissory note, deposited the promissory note, and then loaned you your own credit back to you. Thus, they didn't loan you anything. Thus, the contract is unconscionable. Thus, they committed fraud. See, this is what happens when you read those modern money mechanic manuals, but you don't get the context and you don't realize that the modern money mechanics, those were written in the 80s, in the late 70s, in the 90s, not knowing that bank doesn't, financing and mortgages don't operate like that today. Somebody put the money up, regardless of whether you want to believe it or not. Your loan was funded with real money, not your own credit, not your own application, not your Sesticking V trust, not your birth certificate, not your social security account. No, people actually put up their own money to fund your loan. It's called financing. The theory posits that banks deal in unlawful money or vapor money, and their loans are mere credit that need not be repaid. Irvin versus Bank of America, 2013. Remember that I said this vapor money theories started in the 90s, over 30 years ago. And this court case that I'm reading is 2021. That lets you know how much this mindset has been passed down over the years, that you can tell. In this case, Irvin versus Bank of America, 2013, the vapor money theory states that any debt based upon a loan of credit rather than legal tender is unenforceable. Gene Keating was peddling the same thing. Y'all, Gene Keady was a fraud. He did not get any of those wins that he said he got because every execution that he did was the sovereign citizen way. And what's made me so frustrated with Gene Keaton is because he was a hell of a researcher and he was very intelligent. I give him that. I give him that. But his execution was the sovereign citizen way. All right, let's get back to it. Okay, now, let's get back up. Let's get back to it. All right, so Evans versus Beneficial Inc. Pursuant to the vapor money theory, a loan imposes no repayment obligation on the recipient if the indebtedness was funded with credit as opposed to hard currency. See Price versus Lakeview Servicing, 2021. And it was affirmed on appeal in March 2022. Look, this case it's relatively new. It's only 4 or 5 years old, and they're still making these 90s old arguments. This is why, to most people that listen to him, it's cool. It's groundbreaking. It's new. But when I step into their live and I hear it, I call them out because I already know it's rejected. And every time I say it's not going to work, I can do what I'm doing right now. Pull up court cases where the person made the same arguments as what that person is teaching in that moment on their live. So they're teaching you wrong and they're leading you off a cliff, and your documents, your complaints are going to be dead on arrival based on what that person is saying in the moment. Come on now. A variation of this theory proffered by Alam theorizes that when an individual executes a promissory note in favor of a bank, he has actually provided the bank money. Oh my God. What do they say all day online? This is a court saying it, y'all. This ain't no manifesto or memorandum. This is a judge. This is the court's opinion. This is the judge's ruling. And listen, don't listen to him. Well, if the judge don't agree with us, then the judge is wrong. How asinine does people sound when they say that? How asinine is that? This is what they're saying online. Remember when I say, if you don't like it coming from me, I'll let the judge tell you? This is what I mean. The bank then deposits this money into its own account, listed as an asset on its ledger, and lends it back to the individual. Through bookkeeper procedures, the bank has supposedly created money, and the note is thus void from the outset. That is the hallmark of many people's mortgage defenses right there. See, this is why I tell people you need to join the SETU. We're going to eradicate that sovereign citizen mindset from you. You're going to be eradicated. You're going to be delivered. I've delivered a lot of people. For real. I've delivered a lot of people from that mindset. Wilkinson versus Godson cited the same thing in this case, in which he lost August 19, 2014. The liability is money the defendant owes the plaintiffs for their asset that was deposited. Banks are creating money based on the borrower's promise to repay, as he said in this case. However, claims based on vapor money theory have been consistently rejected by federal courts as frivolous and insufficient to withstand a motion to dismiss. So when I was telling that content creator, everything that you're saying has been rejected by the courts as frivolous, he wanted to argue me down and then blocked me. But I bet you he won't go file the same thing that he's charging everybody else to do for him. I bet you he won't do that. I bet you he won't do that. Come on, man.
You're rocking with the best.
I am your teacher's teacher. I'm not even going to put them on blast. But a lot of these teachers on TikTok, they're really my students in the DMs. Facts. A lot of these teachers, especially ones with large followings on TikTok that y'all run across every day, they're teachers on y'all channels, but they're students in my DMs. That's a fact. I'm not even going to post the DMs. I ain't even going to do that. That's a fact. See also Eastern Savings Bank versus Springer, 2015, noting that these theories have been universally and emphatically rejected by numerous federal courts for at least the last 25 years. The same things that I say, the same things that I tell people. Y'all, they already rejected that in court about 25, 30 years ago. And I think that's the hardest part right there. Thinking that you believe it's so profoundly in something just to hear somebody say, oh, nah, they tried that almost a quarter century ago and it didn't work. It's like a gut punch. I'd rather gut punch you with the reality than pacify you with the lie. Because that's all they're doing. They're just trying to extract money from you to pay their bills. Because remember, y'all, they never practice what they preach. If all these mortgage and auto defense gurus out here, ask them, can I see your title that you won free and clear? Can I see your account that was zero based on the merits of your claims? I'm talking about recognized. I'm not going to ask them. I'm not going to require y'all to ask them, hey, call the other side's attorney. Let him see what does he think about you? See, what I do, that's professional level. None of these gurus are on the professional level with it. I understand that. So I got to dumb it down to at least show the title. Show that you can at least save yourself before you can save someone else. And the answer is no. And it's not me. It's not me, y'all. Y'all have to start putting the press on them. Don't sit there quiet in the chats in fear of being blocked. I guarantee you, them blocking you will be, I swear to God, they'll be doing you a favor. I swear to God, you're not missing nothing. Do not pay attention to the fact that they got a lot of followers, a lot of views, a lot of comments. That don't mean nothing. It's all about measurable results, professional confirmation, and your receipts. That's the only way you know if you're talking about it's true. Not because everybody is saying the same thing. Not because you like the content creator. Not because you've been rocking with it for a while. Not because they show you all these little email wins. It's always an email win. Thank you, we did it. I got my vehicle back. I did it. Hey, video. Look, y'all, as you can see above, we got another victory. What you mean another victory? That's just an email. How do we know? See, they don't expect y'all to challenge them. These teachers don't want you to challenge them. That's the problem. And this is why very few people challenge me, because I do what I'm doing right now. I take it straight to the judge. And God Almighty, me and the judges be saying the same thing. Me and the federal and state regulators say the same thing. Me and the SEC understand it the same way. Me and these corporate finance companies, we understand how these transactions really go behind the scenes. See, we're on par. SETU is on par with the professional level. So hey, it ain't too much, nothing you'll be able to challenge here. Ain't too much, nothing you'll be able to challenge over here. As a matter of fact, it's very rare. The only people that can challenge me are other professionals. Because I'm gonna be honest with you. The Supreme Elite team, we operate from the highly technical side of the game. That side, most people don't even know exists. So that alone is gonna be hard for them to challenge me. Like most people have never even seen a balance sheet. Most people don't even know, yeah, they got items listed on their financial statements, but what do those items mean? What is it really saying? What's the difference between the net receivables and gross receivables? Like we get that deep into it. So I ain't worried about anybody challenging me, because all I'm gonna do is be like, well, the judge agrees with me. The court joins the chorus of disapproval for plaintiffs' discredited theories. Indeed, with all due respect to plaintiffs' rights to pursue claims he presumably has been led to believe have some validity, this case has plainly been a waste of plaintiffs and defendants' time and money and the court's resources. Defendant's motion will be granted and this action is dismissed. Kenneth Bell, United States District Judge, signed August 21st, 2024. That's your vapor money theory. That's they didn't loan you anything. Show me that you loaned me something. That's any variations or spin-offs from it, it's going right in the trash. I don't care what your belief, hey, listen, put beliefs against facts. Put your beliefs in the trash. Let's deal with the facts. I swear to God, when I'm done, when I move on, you're going to appreciate me. I swear to God, I save the people a lot of money. I prevent people from being scammed because I'm going to give you the harsh reality. I'm going to give you the truth. I'd rather you know the truth than walking around blindly buying every package you see that just because it sounds good to your ears. There is nothing about this system that is easy and simple. Securitization is highly complex that many lawyers don't even understand. Accounting is very complex and technical because of the words that they use and the off-balance sheet measures that they use, and they take simple terms and give them new names and new meanings. It's like the deed of trust. The deed of trust has nothing to do with the transaction. The deed of trust is just nothing but a form they use to siphon your property away from you under trust law. Accounting is used to hide the real reality of what's going on. And they use contract law to stick you with the debt. The deed of trust is like a toilet paper. And if you don't believe me, in SETU, we have a guest speaker, a worker that an employee that works for Fannie Mae, Ginnie Mae. He's the one, his job is to process the payments from the lenders to the investors. Okay? That's his job. That's his job. And I got a 30-minute phone call with him. We just having a discussion, breaking down what really happens behind the scenes in a foreclosure. And that's why I hate when these, I don't want to use hate, but I really, it's cringing when I hear people say, this is what the lawyers don't tell you. This is what the lawyers don't tell you. This is what the lawyers want. How do you know? Do you know professional attorneys? Do you know people that works in the higher up levels? Like I do. My stuff is fact checked and gets ran by an ex-SEC attorney, 27 years. Number 2 or 3 on the totem pole, comes from the Morgan & Morgan family. My stuff was being fact checked by the professionals before I even knew I was being fact checked. Because a member of my group, that was his friend. He used to take my stuff back to him and be like, yo, is this correct? Thank God I was on point, because I'd have been put on blast. My stuff hits professionals' hands. I get professional eyes on my stuff. Even when I'm done, even when I know it's spot on, I still have the access. Even if I'm working on a client's case, when I'm done and finished, hey, yo, run this by him. Let me know what he think. Real professional lawyers. And it was the attorney that read my brief before the Supreme Elite Team group did. And he's the one that told my friend to tell me, like, credit acceptance is going to settle. There's no way they're taking this to trial. They're going to settle with him. And Bobby, God damn it, if credit acceptance did. So I believe I listen to people like him. I'm a student of the professionals. Securitization class. What? You know how much it costs? What they got it online? $150? See, that's that low-hanging fruit stuff. You know how much that stuff really costs? Man, that stuff could run you between $3,000 and $9,000 for a 6-hour seminar. Facts. In one day. And you pay cash money up front for it. No payment plans. Securitization classes ain't $150. Master accounting class, $33. What? $50 to get the link. What, man? I can tell that's just struggling to get some money right quick. That's all it is. And y'all fall for it every day. Y'all fall for it every day. And then get mad when the reality happens. When the obvious happens. These people, listen, all my years, even when I was in the federal penitentiary, I was around violence. I was around death. I was around racist COs. The feds are highly segregated, and the federal government perpetuates racism in the feds. I've seen it all, been through it all. This space is worse than the federal penitentiary. I've never seen so much negative and evil and destructive and greed and desperation all wrapped in one. Yeah, I was in a very dangerous place. But these spaces ain't got nothing on Big Sandy United States Penitentiary. Ain't got nothing on Hazleton United States Penitentiary. Ain't got nothing on Bloody Beaumont United States Penitentiary. Ain't got nothing on Canaan United States Penitentiary. Ain't got nothing on Lee County United States Penitentiary. Ain't got nothing on Victorville, Lompoc, out there in the West Coast when the Migos set tripping hard. This space takes the cake. And Bernie Madoff told me, he warned me this would happen. He warned me. Bernie Madoff warned me. He said, first, I'm impressed that you even take an interest in this stuff because many people don't even know this stuff exists. But I tell you this, whenever you get out of here, I don't know how much you got. I say, I'll go home next year, Mr. Madoff. Okay, when you get out of here, let me tell you this. Continue to study, continue to learn, and stay on the path. You're going to be just fine. Do not try to help anybody else because you're going to be trying to help them, and they're so manipulated and stuck in their mindset that they will be fighting you way harder to stay in that mindset, stay in that system than what you're trying to relieve them from. He said, don't do it. You're going to stress yourself out. He said, don't even talk about it to nobody. You get yours, and you just get out the way and let them go. We was at Oklahoma Transit together. He was on his way to Butner, North Carolina. Bernard Madoff. Y'all know who he is. But he did tell me a gem, and that it took me 5 years to understand what he meant. And I finally understood what he meant last year. I understood it last year. He told me this in 2019. I didn't understand it. No, 6 years till 2025. He said, see, the difference between your world and my world, your world, everybody's just infatuated with having the cash money in hand. Like the money is not really the end. The money is the means. This is why you have billionaires who still gets financing, because you get rich in debt. You don't want to not get in debt. You want to get in as much debt as you can get in. The difference between my world and your world, people get into debt to buy things that don't really mean shit. We get into debt to leverage the debt. So, Mr. Madoff, what do you mean by that? We get into debt. Let's say I get $1 billion loan from JP Morgan. Okay. I'm going to take that $1 billion and I'm going to make the consumers pay me $3.6 billion back. JP Morgan gets their money back and I split the difference on the $2 billion, because in my world, the right to receive payment is more valuable than the payment itself. Oh my God.
You're rocking with the best.
God almighty.
You're rocking with the best.
Oh my God. In my world, the right to receive payment is more valuable than the payment itself. Last year it hit me. Oh, that's why securitization exists. Oh, duh. That's why. That's why. This is why the finance companies, they don't give two rats asses if you don't pay back. Why do you think? See, this is what I'm saying. Like, I don't want to get too much into it because it's a SETU class. See, whew, y'all need to get in the SETU, man. Like, oh my God. But anyways, why, like, people actually think that the finance company is nothing more than a glorified middleman. People always wants to focus on the finance company, finance. Who has the right? You can't do this. You can't do, no. See, that's what I'm saying. When you look at it from the professional lens, you understand that 99% of arguments that people make today come straight out of the book of who cares. It doesn't mean nothing. This is why we have securitization. The whole world operates off securitization. No, without securitization, we wouldn't have an economy. See, while most people just study those SEC forms based on their company and this company. See, I didn't just study and read those, even though I've read over 10,000 pages of SEC filings. See, that's not the issue. That's not the problem. The real hurdle that people have when they talk about securitization is fraud is not only Wells Fargo, Bank of America, Credit Acceptance, JP Morgan, yeah, they all got SEC filings. You know who else got SEC filings? Home Depot, Lowe's, Home Goods, Nike, Warner Brothers, Giant, Safeway, Popeye, Reebok, United States Postal Service. You get the picture? Disney, Apple. You get the picture? Over 132 countries participate in securitization using a fiat currency. What are you exposing? A $16 trillion a day industry on the secondary market. What do you think you're exposing? Securitization is highly regulated. It's regulated for tax purposes by the IRS. It's regulated by the Office of the Comptroller of the Currency. It's regulated by the SEC. It's regulated by the FDIC. Like, they even tell them, we know y'all ain't really transferring these mortgages in time. We know y'all not doing it. So since we know that y'all not doing it, and since we know that all that extra interest y'all collecting is all extra free money that y'all jacking up the purchase price of these vehicles in order to cover y'all interest that y'all got to pay and to make some money on the side. We all know y'all doing that. That's why we going to tax you. We know you not transferring these mortgages within the days of the startup date of the remit. We know you're not doing it. So since you're not doing it, you're going to pay 100% capital gains tax on all proceeds from those disqualified mortgages. You know what the finance companies say? Okay, y'all, let's set about $500 million aside just in case we got to pay taxes. That's it. They got tax receivables accounts set up with the IRS. They got them set up with the IRS. Most people think that when you get a refund from your auto or your mortgage, most people think that for somehow, some variation, it's coming from some account. That's not even how refunds happen when you're dealing with securitization. It's not even how it happens. They're pulling the credit from the corporation's tax returns and refund you. That's how it happens. There's no secret method. That's how it happens. This is why you cannot file 1099s in the corporation's name, putting yourself as the recipient and putting your own withholdings there. They're going to check the books. And you're not even supposed to be filing the 1099Bs. You're not even supposed to be filing them. And because one thing, if you know about the history of Forms 1099B, there's rarely, if ever, any withholding. See, it's not about what the teacher tells you what to do. You got to, this is what I mean. people only look at things one narrow, limited way. You got to look at it. Well, how are these forms normally filed? Who normally files these forms? Is there withholdings normally on these forms? And if you just understand from a corporate tax return level, there's rarely, if ever, any withholding on a Form 1099-B. So when the IRS sees a large withholding on a 1099-B, it's automatically going to trigger possible fraudulent return. And then when that happens is, what they're going to do is they're going to put a 570 on your account. And that is going to be under the questionable return. And then they're going to ask you to verify your identity, because they must think that somebody must have stolen your identity, because ain't no way you filed this. That's what they're really telling you when you filed your 1099-B, and then they tell you to verify your identity afterwards. That's basically saying, somebody must have stolen your identity. There ain't no way you filed this. Then once you verify your identity, I hear most people saying, I verify my identity, still nothing. The reason why it's still nothing, because, and this is what they're not going to tell you, but I read this out to my group, you have to file an amended return now and remove that questionable item. Meaning, if they believe the item is questionable, they are not going to give you the credit. That means you have to remove that questionable item. This is why you see people with $32,000 reported income to the IRS withholding up probably like 1,000 or something, but they got 200,000 in withholdings. Where'd you get that from? The same theory and the spin-off theories from this vapor money theory. The same theories, which a person tells them to do 10 times the amount, because the Federal Reserve monetizes 10 times the amount. What does the Federal Reserve monetizing something 10 times have to do with your tax law? The Federal Reserve has no connection to individuals. There's not a private account on the books at the Federal Reserve. There's no secret account. The letter and 8 numbers that's on the back of your Social Security card is just a trace number. It just logs in their system that this card was actually issued to this person. That's all it means. That's all it means. So when you were taking that letter and finding what Federal Reserve Bank routing number that corresponds with it, and then you're putting your Social Security or your EIN number as the account number, but then you're putting the Federal Reserve routing as the routing number, and then you were sending that into the IRS. And per the IRS's deposit manuals, they always have to deposit those instruments within 24 hours. So when it pops up as a credit, you think everything went good, not knowing it's another 2 to 3 week process on the back end, because it got rejected within 2 days from the Federal Reserve, but the IRS resubmits it. And then they reject it again. And then they reject it again. And that's when they reverse the account. And if you slept through the cracks and they already gave you the check, you know they sent you a bill stating that they made an error. As a result, you owe us this amount. And what did they do after that? They look for groups and look for teachers and look for ways to keep the money instead of giving it back. To be honest with you, you will have a better chance of just sending the money back and just sending a letter to the IRS saying, hey man, since I showed a good act of faith, can I keep it? Because I know plenty of people don't ever send the money back. Can y'all show me some grace here? You'll be surprised. They may kick the check back out the door to you just for like rewarding you for doing the right thing. You never know. But you're better off doing that. And this is why I'm unpopular, because I don't teach people how to commit fraud. I hold people accountable. I don't tell them, oh, just don't pay your bills. I don't. Because I do things the right way. And if I got to be unpopular and do things the right way, instead of being popular and feeding into the delusions and the beliefs. If I told everybody I won my case because of what everybody talks about today, I sent my birth certificate in, and if I told everybody I did that, people would be flocking through the doors trying to get services. Y'all don't know that all I had to do, do y'all do realize that all I had to do was just tell y'all I do things the sovereign citizen way, the estate, the trust way, then go behind the scenes and do it the correct way? You know, that's all I really had to do. I mean, you would still get positive results because I'm doing it the right way, but I'm just leading off this way. See, that would be misleading. I could have easily done it that way, but nah. And what I'm trying to tell y'all to understand is there is no separate accounting system for a subset of people who think the same in the rest of the world. You cannot submit any instrument for deposit, regardless if it's a special deposit, regardless if it's a bail or bailee, regardless if you read the Negotiable Instruments Act, regardless, when you submit an instrument for deposit, there must be a corresponding account with the debit on it in order for that check to be made good. Y'all, we all know these things. We've been alive long enough. We know these things. You know, if you write a check on an account that doesn't have any money in it, you know it's going to bounce. So why send one of those things to the IRS? Why send one of those things to your finance company to pay your bill? Because all they're going to do when you send it to your mortgage company, they're going to send it over to the FBI. It's considered mortgage fraud, and it's considered bank fraud. And since you use the mail to commit fraud, now it's considered mail fraud. And if you received any proceeds from it and you transfer that money to another account, it's considered wire fraud. You see what's going on here? You see what's going on here? And you can't come in court and say, I'm not the corporation, not in the feds. Oh, let me tell you this. All those, that's not me. You ain't got jurisdiction. You notice how people only talk about those arguments related to catching a traffic case, like little state traffic cases, because they know none of that works in the feds. The federal government, the Fed courts, they are waiting on those arguments because they've been seeing them since the 80s. You really want to know if your arguments are really true, Admiralty Court and all that, go step in front of a federal court. Oh, they'll bring reality fast. Yeah, that's all you got to do. Don't listen to me. Go take your ass in the federal court, see what happens. Go ahead. And tax season's coming around. I understand that. Yeah, I get it. We all know what's happening. 1 second. I feel a cold coming back on. God damn it. Woo! I can't seem to shake one. I can get rid of one. We know what's going on, y'all. They know what's going on. The IRS actively watches apps like TikTok to find out what the next scam is going to be. They're actively going to. So, no, I'm telling you something good, y'all. So, my question is, why does everybody want to quote Title 15, Section 1602, 1692? Why do they always want to quote these things? But then, right here, when we look at the term creditor, because the argument is, you didn't loan me anything. You're not the creditor. You didn't give me anything. I've never heard a coherent reason to substantiate that claim. But if you look at definition 1602, 15 USC, the term creditor refers only to a person who both, one, regularly extends, whether in connection with loans, sales of property or services, or otherwise consumer credit, which is payable by agreement in more than 4 installments, or for which the payment of a finance charge is or may be required. And 2 is the person to whom the debt arising from the consumer credit transaction is initially payable on the face of the evidence or indebtedness, or if there is no such evidence of indebtedness by agreement. So right there, the initial person who you filled out the loan documents with, the initial company, that is the creditor. If they assign servicing rights over to another company, they are allowed to do that by law. It's not a crime. It doesn't mean that you still don't owe. It does, just because they assign servicing rights doesn't mean the servicer doesn't have enforcement rights. Because believe it or not, And one of the perks of me being connected to those people, I get a lot of like internal stuff that the average consumer would never get. I've actually seen the agreements between these servicers. In the event of default, you are authorized to foreclose on our behalf. I've seen it. I've seen these things. In many cases, they are allowed to. So when they're on TikTok calling Carvana, but you're Western Star Servicing. You're not. I didn't get the loan from you. Oh, you're committing fraud because they put it down as you can repossess. I didn't. None of that matters. See, these are all useless arguments because many people does not realize that there are more than one lens to a consumer contract. The consumers look at the contract one way, and they're going to judge that contract off consumer law. The courts look at the contract a totally different thing, mainly an enforceable agreed obligation to pay. The corporate finance does not view the contract the way we think they do. They're not looking at the payment terms. They're not looking at the amounts financed. They're not looking at the total of payments. That's not how they view the contract. The regulatory agencies does not view the contract in nowhere near the consumers. It's all risk-based, capital-based. And the investors view the contract in a totally different way. The only thing they worried about is the performance. When we gonna get paid? So you got 5 different lenses to one contract. SETU teaches you the other 4. Because I agree, many people got the consumer laws and all that stuff down pat. But if the consumer laws was all that you need, why is the success rate still not the level reflected of everybody's consumer law knowledge? Because the reality is it's not enough just to know the consumer laws. You got to know the corporate laws. You got to know the accounting. You got to know the internal controls. You got to know case law. You got to know case citation. You got to know the court rules. You got to know the court procedures. You got to know the regulatory. You got to know the regulatory agencies. It's a whole system within the system. Everything that I'm saying is what I executed. I've already executed this. So I can tell you from experience. I'm speaking from experience. Right now, I got United Wholesale Mortgage running. They filed the foreclosure complaint against my client. Look at this. They filed a foreclosure complaint against my client. Well, those are my friends and they're my group members. June 23rd of last year. They so-called assigned the mortgage to Lakeview Loan Servicing December 22nd last year. We responded to the complaint. The judge ordered a contested call hearing. UWM did not move for summary judgment. January 13th was the contested call hearing. Remember, they already assigned the mortgage to Lakeview December 22nd of last year. So after they filed the complaint, once they knew that they did the assignment, they didn't say anything to the courts. Contested phone call January 13th. They're getting the dates when they got to respond to our counterclaims. They had all this done. And for somehow, which I could find very suspicious, the order, they forgot to put the order into the record. So they already knew which dates they had to respond, but you got to have that order to respond on the record. So they were supposed to respond by February 12th. They never responded. Now, last week, they filed a motion to substitute plaintiff. And we're now in February. You did the assignment December of last year. Well, why did you wait so long? Because all you really did was just throw Lakeview right under the bus. That's all you did. But UWM, why didn't you answer to our response to your complaint and counterclaims? Why did you now want to let the courts know that you already, oh yeah, by the way, we're not the proper plaintiff. Lakeview is now. UWM, why didn't you just do that months ago? Right, because they couldn't get from up under this scalpel, and now they want to throw Lakeview under the bus. That's all that's happening.
You're rocking with the best.
We know that's what's happening, but it's all good. Because to be honest with you, Lakeview, I want the battle with the big dogs. I want the battle with the largest wholesale mortgage lender, which is UWM. I want them. Lakeview, I don't really care about them. I want them because I want these corporations on my resume. Got Navy Federal under my belt. Got Credit Acceptance under my belt. Got Midland under my belt. Who else? We got who else? I forgot. Oh, Santander under our belt. We got a few scalpels coming up. And no, everybody that reaches out to me, they got variety of situations. I mean, to be honest with you, I love the mortgage and auto more because it's more at stake. And this is a chance to really prove that you can get titles back free and clear, retrieving your piece of the American pie. I'd rather deal with those because it's the biggest challenge. It don't get no bigger than those two from a consumer standpoint. Credit cards, those are like, I've kind of transcended from those. I mean, it's not a real challenge to me anymore, but people do have those situations like debt buyers, not a real challenge, but people does have those situations. Student loans, yeah, but people still have those too. So whether it's a mortgage, auto, credit card, student loan, debt buyer, federal, state, bankruptcy, we are well-rounded. We can handle a variety of cases. I would love for people to be current because it puts us in a more powerful position, but I deal with defendants too. Hell, everybody else right now is a defendant. Now, notwithstanding the preceding sentence, in the case of an open-end credit plan involving a credit card, the card issuer and any person who honors the credit card and offers a discount, which is a finance charge, are creditors. Right there. So it's basically saying it doesn't necessarily have to be the third party who ends up getting it. Whoever they sold it to is the creditor. Right there at the origination, they're the original creditors. And then they assign it. And once they assign it, then they become the creditor. That's just how it goes. I ain't got no contract with you. You know, like with debt buyers, like 10 years ago, all you had to do was say, hey, show me the contract with you. When debt buyers would come, because that's a multi-million-dollar industry. So what debt buyers is, you set up an LLC, you get financing from a bank, you buy up a whole bunch of debt, and then you issue it for payment, and then they don't, you sue them, right? The problem is they do it so sloppily because most people, when they have a debt collector reach out, don't ever call back, or they don't show up to court, or they get on a payment plan. But they do it so sloppily that it's easy to defeat a debt buyer, just like it's easy to defeat a credit card defense. It's not hard at all. So my thing is this: when are we as a people going to start to actually benefit from an asset standpoint with this? I think it's safe to say that we can do away with the multi-million-dollar secret account dream and come back to reality. I think it's time to do away with that. No one has ever accessed it. No one. And if all the people that, well, I know someone who had, then they must not be real cool with you if they didn't help you put you on for free since they got all those millions. I've never met any millionaire, and yes, I know a few. I've never met any millionaire or have known of any millionaire who is going to charge regular people $500 to access their own billions. Like at that point, like Why would you still need someone else's $500? Why would you even be wasting time? You should be out there major investments, building your own repertoire up. This would be a waste of time for them. But for $500, they're going to help you access yours, because they've accessed theirs. So when you get to talking that large amount of money, y'all, let's just be honest. The process don't even matter. Them showing you how they going to do it and showing you the laws, it doesn't matter. Show me your mega mansions. Show me your portfolio of assets that you own. Show me, because people love to show what they have. They love to show their little so-called wins. They love to do that. When you start talking that, and this is what puts a lot of these gurus under the gun, you're talking about something that has never been done before, and you're offering that as a service. Once that amount of money comes involved, people psychologically want to see the money on you first. They want to see the money on you. They don't want to hear about how the process goes. They want to see that money on you. Show me your millions. Show me that you live like a millionaire. Don't talk about you holding classes and how to help you access your estate and you're a mystery. Nah, show me that you living like it. Show me that you at luxury hotel. Like, show us that you really about that. And if you really know how to do it, why would you need to charge $500 up front? You know how to get them to access their estate, right? Okay. If that's the case, check this out, y'all. How about they just do it? And then they're going to send you a bill for about, let's say about $1 million, 10 million. You see, all these things, these logical questions, y'all got to stop paying attention to. Now, here's another thing. Here's another thing, y'all. The definition of credit card means any card, plate, coupon, or other credit device existing for the purpose of obtaining money, property, labor, or services on credit. Y'all, that does not mean your social security number or your social security card. That does not mean your social security card. Another myth that I'm going to debunk, another myth is 28 USC 3002. The United States, what they say, the United States is a corporation. Okay. Now look at here. It's under 28 USC 6, chapter 176, subchapter A, section 3002. Okay. The first thing you have to look at is, what does the chapter say? The heading of the chapter says federal debt collection procedure. But this is how they think of it. They had to scroll and see that it says federal debt collection procedure part 6, right? So they've had to see that. So a person with just a little intellect would normally think that, okay, this is in the context of federal debt collection. But what they do is they read something that's saying that the United States is not a country, it's a corporation. So once they seen the definition of 3002, that the United States, hold on, let me get to the, so when it gets to the United States, see, they scrolled all the way down to subsection 15A, and it says United States means a federal corporation, an agency, department, commission, board, or other entity of the United States, or an instrumentality of the United States. Bam! The United States is a corporation now. Now, here's the problem with that. Because they never understand context. It's all a literal meaning, literal interpretation, what it says, what it means. But anybody that works in the professional world knows that statutes and even case laws, they has context to it. So it's not that cut and dry as to what it says is what it means. But when you take it in as a whole, you can get the context. That is what's devoid of these spaces, context. So the United States means, when it says a federal corporation, it means a GSE, like a government sponsored entity, or a corporation set up by the government, like a United States Postal Service. You get what I'm saying? It means that a corporation of the government. Right. That's what it means. An agency, department, commission, board, or other entity of the United States. An agency, that could be the Internal Revenue Service. Department, that could be the Small Business Administration. That could be the Student Loan Department. The commission. You already know all those government commissions that they got. Board or other entity. So that's dealing with the agencies of the United States, the different departments, the different sections. And this is in the context of, remember, federal debt collection procedure. So the Small Business Administration fits the bill. The student loan, whatever the government student loan, whatever you went through the government to get a loan, that's what it means. Or you own a debt to an agency or department, like you own a debt to the Department of the Treasury, in which the agency, the Internal Revenue Service, is collecting the debt on behalf of the Treasury. It didn't mean that the United States itself is a major corporation now. It is no longer a country. And C, an instrumentality of the United States. That means the banks and financial institutions. That's all it meant. That's all it meant. That's all it meant. See, you could take a pen. Does anybody have a balloon on hand? If you have a balloon on hand, don't go get a pen. Just take what I said. Use that as a pen, because another myth has been popped. But this is the problem. All these things, these are not even conversations in my circle, because this is all a matter of general knowledge. Like, this is not something groundbreaking I just informed you on. This is like, you did not. This is more of a like, yo, you actually thought that it meant that the United States was like a corporation? Like the whole country is nothing more than a corp? You really meant that? Like the people that in my inner circles, like that's how they looked at you. No, they'd have been like, yo, please don't tell me you actually thought that it meant that the government itself is a corporation. Tell me that's not what you meant. Yeah. It's like, bro, it's not even. And here's the thing. Look at all these other definitions. You notice how they always scroll down to United States, the federal corporate. You notice how they scroll down and just interpret it to mean that. But the context is telling you debtor means a person who is liable for a debt or against whom there is a claim for a debt. Disposable earnings means that part of earnings remaining after all deductions required by law have been withheld. Like the debt means an amount that is owing to the United States on account of a direct loan or loan insured or guaranteed by the United States. That's the government-sponsored entities. Those are your Fannie Mae's. Those are your Freddie Macs, your Ginnie Mae's, your Penny Macs. That's what it meant when it says the federal corporation, like the corporation of the United States, not the United States is a corporation. Like, I know we did not believe that. Like, I refuse to believe that people are actually making those arguments on paper, are actually coming out their mouths saying that in court. And I hope they wasn't doing that, because if they were, yo, we really have a long way to go. The social is used to identify you. That's all it's used. It has nothing to do with whether you're getting credit or not. The Social Security identifies you. They can run your credit report. They can run your credit score. And this is the thing. When you say, well, why not? See, this is not about what it should be. This is what it is. So anything outside of this is just what it is, it's just a personal opinion on what it should be or how it should be. But over here, I don't deal with how things should be. I deal with how things are because it saves you a lot of time, energy, and stress, especially going down rabbit holes that are not going to lead to anything fruitful. See, over here, we don't bump our heads to learn what not to do. Over here, we just look in the landscape and see everybody else bumping their heads. So that lets us know we already know what stuff to stay away from. But then we do deep, in-depth research into all these claims. And I don't judge whether something is true or not based on what other people saying, based on what I feel, based on how it should be, based on how I want it to be. I base it off who is responsible for granting me the relief based on these claims presented. I go by what they say. I go by what the courts say. I go by what the agencies say. And the reason why I go by it, and it's easy for me to go by it, because I don't have this us versus them big conspiracy. The government's just trying to keep their foot on my neck's mentality, because that leads me to be biased in my approach. See, I don't approach it like the finance company just woke up, has my picture hanging up in the boardroom, and they're trying to look for all different ways to stick it to me. See, I don't have that mindset. I don't have that mindset that they're just trying to prevent me from asserting my rights when you're nothing more than another account amongst hundreds and thousands of different accounts they have. You see what I'm saying? See, that puts things in a proper perspective. So, and it keeps me from not having this victim blame mentality. So when I'm off in my assertions or my claims are frivolous, it would allow me to look at myself as, what did I do wrong here? There's something I must be missing, instead of writing it off as, oh, they just don't want the truth out. Oh, this the typical proverbial government. They always want to suppress the truth. You see what I'm saying? Because if I had that mindset, then I would be developing the mindset of many people, which is they're never wrong. The judge is wrong. The government is wrong. Somebody else is wrong. But it's never me that's wrong. It's my arguments can never be wrong. They're right. It's just they don't want my truth to get out. They don't want me to expose the fraud. No. They don't want the fraud exposed. So they're doing this to block me. See, that right there is a very narcissistic, very self-defeating, negative, and one of the worst angles to ever look at this stuff. Because either you're right or you're wrong. There's no gray area. Either you're right on your arguments or you're wrong. The courts have a set of rules that they have to follow. They got a set of rules that they have to abide by. And yes, they follow them. Just because a judge rules against you does not give you the right to go sue the judge. On the heels of everybody online that's saying, oh, I just filed a lawsuit against the judge, which is always going to get thrown out because judges have immunity. But I guess they didn't tell them that part when they was mad and ranting and looking for someone to blame. But every lawsuit I hear when someone says, straight up, every time I hear someone says they just filed a lawsuit against a judge, I automatically think they're a sovereign citizen and they're mad because their frivolous claims wasn't accepted. That's all it is. That's all I see. Because when I actually start to read the claims that they filed, it's always some legal conclusions, some threadbare assertions. Oh, they can't put me out the house. I have title under God's law. I have the highest title. I'm under God's code. Corporations is not over a human being. That's why I have the title. See, over here, we have full title when the finance company sends us the full title with the no liens on it. See, that's when we know we have full legal title. Over there, they have title when they think they have title. This is why they go file liens and file UCC ones and all that stuff. See, over here, our accounts are zero. 1 second. Over here, over here, hold on, somebody's calling me. And be prepared, because I think you better be prepared too, because I think you owe me a payment on. I gotta check the books. There's probably a few people that owe me. I ain't check up on it. Hey, if you owe me, I'll be around to you. I'll be around to you today. Don't sweat. I'll be around to you. Because I just don't be blowing people up. Because I be so damn busy. We'll get to it though. See, over here, our accounts are zeroed out when they send us written notification that it's zeroed out. And they send us written notification that we don't owe anymore. Because when you don't owe anymore, they do give you notice that you don't owe anymore. See, over there, their accounts are zeroed out when they send them an affidavit and they didn't rebut it within 10 days. See, in their mind, they think the debt is discharged. See, over here, we own the house when the satisfaction of lien is recorded and there's no more liens in judgment. See, over there, they own the house when they break in and squat in it and file paperwork saying they own the house. See, they own the house when they believe they own the house. See, over here, everything is black and white confirmation on the books. We don't go to jail after getting satisfaction of liens in our house for being in our house. We don't get our vehicles repossessed after we getting the legal titles to our vehicles because everything is settled and done. Over there, that's exactly what happens. Over here, you see the difference? We don't believe things are done just because we want it to be that way. Like, prime example, if you owe $25,000 on your auto and you're about month 2 behind, because it's usually between month 2 and 3 when a person gets behind. Okay, this is how it goes. They get their auto contract. They make the down payment. They made about the first 3 or 4 payments on the vehicle and then comes to realize, God damn, I shouldn't have got this vehicle, but I need the vehicle because I got to get around. But these damn payments, I don't want to pay this shit. And who really want to pay a bill? Nobody want to pay a bill. I get it. So what they'll do is they won't make the next month's payment. Then they won't make the following month's payment. And now they get the letter saying your account is severely past due. And then they start to panic. And then they'll go online and then they'll find a class or they'll learn from somebody. And then they'll go to the store and go get a $1 money order. They'll go get a $1 money order, right? Not knowing, see, they're so focused on, I don't want to pay this bill, but I want to keep the vehicle. I really know I'm not giving them anything of substance that will bring the account current. So I'm going to use this little legal loophole, this little pseudo legal law from this class that I taught, because money orders are backed by gold and it's part of our trusts and our account, and they took our gold and they didn't give us a right to pay. And HJR 192 had nothing to do with paying private debts. And I read the whole HJR 192. It said nothing about private debts. The term wasn't mentioned at one time. And even if they took people's goals back then with the executive order from April 1st, 1933, everybody's gold who they've taken, they gave them legal tender in exchange. And since no state shall make anything but gold and silver as payment of debts, no states shall make it. Well, guess what? No state does, because every state adopts Federal Reserve notes as their currency. So when you get paid for your state job, you're getting Federal Reserve notes. So there's no gold and silver that comes into play there. See, I'm taking everything I'm saying would happen with HJR 192, and then I'm transposing in real life. So you can't refute real life. So no state has made gold and silver as payment of money. No state has ever paid you in gold or silver. No state or no contract in your lifetime has ever demanded payment in gold or silver, because that's all HJR 192 really meant, is demand for payment from gold and silver will be discharged dollar for dollar in whatever amount is legal tender at the time the demand for payment was made. Meaning, if I had a contract with you and you wanted me to give you like gold, whatever, let's say the gold amount came up to $100 cash. Instead of giving you gold, if I gave you $100 legal tender, Federal Reserve notes, then the debt was deemed paid. It didn't mean that you create your own instrument and pay the debt, citing HJR 192. HJR 192 didn't mean that since they took the gold from people, there's no way for us to pay their debt. Because the Constitution says that, oh, no state shall make, once again, no state. And the states have not violated the Constitution. But the Constitution did allow the government to create legal tender. And since gold and silver was the actual lawful money, they went off the gold standard. Because prior to 1933, gold was actually backing the dollar. So once they got off the gold standard and abrogated the gold clause, now Federal Reserve notes is backed by the full faith and credit of the United States. Not the full faith and credit like our physical credit. See, there we go with these literal interpretations, these literal meanings. All these literal meanings. They take everything literally. Everything's gotta be a literal interpretation. No, it's not what it meant. What it meant was the government is going to guarantee, whether through taxation, whether through them issuing bonds, whatever, it's going to be paid. That's basically the government saying, no matter what, you're going to be paid. That's all the full faith and credit means. It doesn't mean our private property was hypothecated and transferred to the government for the pay. It just means that it's going to, you have our word. You have our word, it's going to be paid. And since the way they set up the fiat currency system is the Federal Reserve notes are no longer retired unless they're outdated, it just circulates as currency. So if I owe John $100, I give this $100 bills. John owes Timmy $100. John gives Timmy the $100 bill. Timmy owes Susan $100. Timmy takes that same $100 and give it to Susan. Susan owes Andre $100. She takes that $100 and pays Andre. Andre owes me $100. I get that same $100 back. The $100 is back with me, but everybody else's debt is discharged in a way. That's how the system works. That's how the system works. So since there's no actual redeeming Federal Reserve notes anymore, citing Title 12, Section 411 is outdated. You can't take your $100 bill to Washington, D.C. at the Treasury and redeem it because Federal Reserve notes are no longer redeemable in gold. So since we cleared up what HJR meant, we cleared up that everybody who they took gold and silver from, they received legal tender in exchange. Since they made legal tender, Federal Reserve notes the national currency, you do have a way to pay your debts through Federal Reserve notes, debit, credit card, cashier's check, a money order, which you exchange cash for the amount of the money order you wish. So we know how the payment of debts work. So why does it come when you're now in default, you want to start playing this HJR 192 game? You notice how the HJR 192 only comes into play when they're trying to get out of a debt. But this is the stuff that they tell themselves. They tell themselves this. Yeah, notice that they tell themselves that this is the right way, knowing their own realities is saying something different. And this is the problem with these spaces. This is how dangerous it becomes. It has your mind thinking something that you already know is not true, but you still go along with it, all because you're trying to get out of this obligation. And this is more the reason why everyone, if they humanly possibly can.
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby. Folded thicker than a skyline. Credit acceptance on a resume. War stories in the fine lines.
Sounds good. Man, you know. If you don't know by now, I don't know what to tell you. These must be in reference to all their SEC filings. The whole world operates like that. It all operates like that. You know, it all operates like that, y'all. So whatever the case may be, so when they issue the $1 money order, just know that there's the serial number is imprinted on the $1 money order. So that serial number is what lets them know that the money orders were issued in that amount. That's how they track the amount. You cannot write scratch out the printed amount and write the written amount just because you read that UCC statute. The only way that you can do that is if you gave them $1,000. If you gave them $1,000 for money order, you got two $500 money orders, but they give you one $500 money order and then they give you four $100 one, and you have your receipt, right? You can scratch out the four and put the 500 there as long as you got proof and evidence that you gave them an actual $1,000 for that. The problem with that is they don't make those mistakes on money orders. And y'all know they don't. You give them cash, they bring it up, bam, 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 bam. They don't make those mistakes. Because when you pay for it, the computer, how much you want the money order for? $400. Bam, 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 bam. All right, you owe $401. There's no mistake there. And it's going to print it out. So when you're writing off, scratching out the $1 and putting the amount down, you know you're just being disingenuous. Like, it's like they know what they're doing is illegal, but they tell themselves these are their rights by law to do so. Or they have some type of special authority to do something just because they're not a United States citizen. It's all the same googly, goggly glop. It's all it is. So this ends, I hope this ends the federal debt collection. So when we get down here, just know that the United States, when it says corporation, doesn't mean it in the literal term. It means the corporations of the United States, government-sponsored entities, agency, the Treasury, Small Business Administration, or bank. It didn't mean the United States was a corporation within itself. Hey, yo, I can't lie, yo. I'm not even going to say it, but I would literally check the IQ level on many people who actually believe that. Like, I'm sorry, y'all. I mean, I don't want to, you know, it, yeah. So, the sovereign citizen movement, made up of individuals who do not believe they're under jurisdiction of the federal government, appeared to flit through the United States District Court for the District of Minnesota when a mortgage holder sought to discharge his home mortgage loan and home equity line of credit on the vapor money theory. Although the court, in an opinion found Monday, agreed with the defendant that the claims were meritless and statutory claims were frivolous, it declined to award monetary sanctions against the mortgage holder. Preston Knapp and his wife Michelle reside in Hennepin County, have a mortgage loan and a home HELOC with Wings, a state chartered credit union. Under the terms of the mortgage and home HELOC, Knapp must make a payment when the loans are due. Knapp agreed to pay $1,119,400. However, Knapp claimed in a lawsuit that he was not required to repay the loan. He cited the vapor money theory, which posits that those who take out loans do not have to pay them back because the indemnity was not funded by the lender with actual money. Isn't that what they claim today? That's what they say. While Knapp filed the lawsuit pro se in November 2023, he appointed Brandon Joe Williams as an attorney in fact. That's another sovereign citizen term, attorney in fact. On Williams' website for the Williams & Williams Law Group, Williams is not listed as a licensed attorney in Minnesota. On his website, Williams states that he is absolutely not, nor will ever be, a member of the bar. I refer to myself as a lawyer or attorney just to keep it simple. William also says that his behavior is permissible as he does not view himself as a United States citizen. I practice freely in all 50 unincorporated states where there is no jurisdictional risk for not having a bar card to be an issue in courts. William asserts on his website. Other litigation involving Nat in the U.S. District Court for Minnesota in June 2024. The court took judicial notice that Williams is not a licensed attorney. While Knapp argued that his choice of legal representative is protected by fundamental due process right, the district court judge, Susan Nelson, disagreed, citing Minnesota's strong public policy against unlicensed practice of law. See, this is the difference between what they believe is true and what is actually recognized as legit. It's the difference right there. Nevertheless, Knapp appointed Williams as his attorney in fact. Williams subsequently sent Wings, that's a weird name for a credit union, orders that included an unconditional tender of payment in accordance with UCC 3-603. Who else sent a tender just like that? You guessed it, Kenyatta Stone. Kenyatta Stone. Who else sent the tender of payment in accordance with UCC 3-603? Kenyatta Stone. And an unconditional order to pay. Knapp also claims that he sent another entire promissory note in order to perform on the mortgage. Knapp's lawsuit alleged breach of contract, breach of fiduciary duties, and alleged violations under 12 U.S.C. Section 504. You ever notice how they all use that breach of fiduciary duty, breach of contract, breach, while they're themselves in breach because they defaulted on their loan? Any member bank and any institution affiliated party with respect to this member bank who violates any provision of Section 371, 371C, 375, 375A, 375B, 376, or 503, or any regulation issued pursuant thereof, shall forfeit and pay a civil penalty of not more than $5,000 for a day during each violation continues. Okay. Any bank may arrange, purchase, or sell or extensions of credit secured by liens on interest in real estate subject to 1828 of this title. Notes representing loans made under the sections to finance construction. So, no violation. There's no violation there. So what he cited was wrong. Let's see. Banking affiliates, nothing wrong there. Has nothing to do with what he's trying to argue. 375, extension of credit. No member bank may extend credit to any of is executive officers, directors, or principal shareholders, or to any related interest. This has nothing to do. This has to do with the corporate officers at the bank. This has nothing to do with a borrower. See? This has nothing to do with the borrower. This has nothing to do with, look, just walking all his claims down. Look, loans to executive officers of the banks. That's nothing to do with him. See what he's citing? See? Let's go 375B. He cited that too, right? Look, extension credits to executive officers. That's what I'm saying. You see what I'm saying? I told you their misinterpretations of the statutes that they cite is what does them in. Now, he also asserted violations of securities-related criminal statutes, including Chapter 77 of Title 18, to peonage, slavery, and trafficking in persons. This is all. I'm mad that I have to pay my debt, and you're not letting me get away with my delusions. That's all it means. I'm just mad. And since you're not giving me my way, here, you're violating criminal statutes. Title 18 USC does not give private citizens a right of action. Private citizens cannot use Title 18. That's for the federal prosecutors. See what I'm saying? See what I'm saying? Woo! Hey, y'all, that mother aged like fine wine, didn't it?
You're rocking with the best.
That aged like fine wine, didn't it? Can't say I was wrong. I called that, didn't I? Nat sought full release of interest and liens on the property, full discharge of loans, and $50 million in damages. And behind all these claims are financial turmoils. 50 million. Like, let's just once again see with SETU, you would never have to worry about making a fool out of yourself. Because I know there's a few of y'all that have tried this before. Fee schedules. Y'all been down the rabbit holes. And instead of feeling bad or me feel like I'm peeling back scabs off old wounds, don't get mad at me because something that you chose to do freely. You chose to file those documents. You chose to send that frivolous stuff, and you chose to make a fool out of yourself because you thought that was your mindset. That was your mindset. Own it. That's never been my mindset, but own it. You know, I didn't fall down the same rabbit holes a lot of people did. Because I already knew by just dealing with the federal government, that stuff wasn't going to work. They give it to one, they got to give it to all. But go ahead. Keep falling. Keep thinking that this is going to be your financial freedom. This is going to be your way out of your current reality. Keep thinking you're going to obtain generational wealth by issuing documents. Go ahead. Keep thinking it and don't go out here in real life and do the real work. Go ahead. Just in 20 years, do not become bitter and mad because you left nothing behind, because you spent half your life thinking that it's all going to be good once I access it. Don't just be mad at yourself. Don't be mad at the government. Be mad at yourself. Because at this point, many people have been warned. They just have to believe in this stuff because they really lack the confidence and the skills to go out in the real world and do it. That's all it is. While Knapp filed the lawsuit pro se, the case is listed under cases on Williams' website with the comment, "This is our first official prototype of infinite money." Williams also discusses a client in Texas who claimed to be in a P&I situation where his farm was pledged as collateral for a loan. Williams has also filed a lawsuit pro se against American Express, which he characterizes as a magnum opus, seeking full discharge of loans, $250 million in damages, and optional a black card with no credit limit. So this is basically, regardless of what the claims that they think or how they've been damaged, this is nothing more than the typical sovereign citizen way of extracting money out the government in these companies. It's all a way just to get free money. Although the U.S. District Court for the District of Minnesota was not completely clear on what Cap alleged in his lawsuit against Wings, the court affirmed that Knapp argued that by signing these documents with a special endorsement, Knapp believed he converted the document to negotiable instruments that constitutes payment in U.S. dollars, which satisfied his loans with Wings. Hey, Kenyatta Stone, didn't you think the same thing happened in your case when you tried to buy a home with the fake check?
You're rocking with the best.
Ain't that what she tried? I believe that's so. The court rejected Knapp's breach of contract and breach of fiduciary duties claims, rejecting the vapor money theory. The vapor money theory is the idea that those who take out loans do not have a requirement to pay it back because the indebtedness was not funded by the lender with actual money. Put differently, promissory notes are money that anyone can create through signing. See, this is why I'm so glad that I actually worked with professionals, soaked up game from them, because many people think that all you have to do is just write a promise to pay, and now that's money. It's not the promissory note that is the valuable asset. The promissory note is the vehicle in which receivables are created. Okay, let me bring it down lower. A promissory note that has no payments coming in to back it, whether installments or lump sum at a specific date, with or without interest, has as much value as a used piece of toilet paper. If I give you a promissory note for $1,000, whether with or without interest, when the due date is due, I hereby promise I will pay within 30 days. That means within the 30 days, I have to have the $1,000, or I can be sued under the promissory note. Just because I signed the promissory note doesn't mean $100 was just created. It doesn't automatically convert the note into 100% cash. And this is why these people have a unrealistic and a very buffoonic way of looking at the financial system. This theory has been consistently rejected by federal courts in this district and across the country as frivolous and nonsensical, wrote Judge Donovan Frank. The court also rejected Knapp's claims that Wings was benefiting financially from peonage, slavery, and trafficking in persons. What is clear from the pleadings is that plaintiff obtained a loan of over $1 million. See, that's clear, to purchase his house. The argument that plaintiff is now being subject to peonage, slavery, involuntary servitude, or forced labor because Wings is requiring plaintiff to pay back the loan is frivolous, nonsensical, and unsupported by the law. And let me ask yourself this question. Let's all ask this question. Why is it that number one, why is it that these people can sign the promissory note, right? They can agree to pay. right? They can do all these things, right? Why is it that they can do that? But as soon as it gets down to paying back, now it's peonage. Now it's slavery. Huh? Where's it at? Why does it always have to come up now? And that's what makes it disingenuous. Now it has to come out. Now all of a sudden, the contract is over with. I find that very interesting. Why didn't they raise this from the beginning? Why didn't they just raise it from the beginning? And I want y'all to ask y'all that question. I want y'all to, I really want y'all to answer that question. And please, can we be honest? Can we be honest? Why do you think now that's the argument? Just let me know. Put it in the comments. Why is that now the argument? You know, so uh and until we actually confront that, people are still they're going to continue to act like that side of it doesn't exist. They're going to act like it doesn't exist. Because what you don't want to do is continue to to uh continue to put this stuff and act like this stuff don't exist and continue to do this and continue to do that and continue to do this and continue to do that and continue to do this, continue to do that, this, that. But when it gets down to the real X's and O's, nobody has an answer. I mean, it gets sad. It really gets sad. Like, forget all the other stuff, y'all. Just look at this. Look. And this is all that they're teaching you to do. It's all that they teach you to do. It's all they teach you to do. So let me pull this up for y'all. So now it's a sad day. And this is why I'm glad with the Supreme Elite team, like we don't like it would be 5,000 times worse if we were still sitting, if we were still sitting like everybody else with the mindset. Like we were I thank God every day. I'm gonna be honest with you. I thank God every day that there's at least a few people out here that wants to do things the right way. I swear to God, because I'm gonna be honest with you. If we were oh my gosh, it gets so worse. It would get so worse. It would get so worse. Like I actually feel sorry for these people. I actually feel sorry for these people. I really do.
Bank representatives from the bank are here and legal aid is here. Let me give a little history here. The summons and complaint was filed as a foreclosure action. Farmers State Bank repossessed this property as a result of a foreclosure. The parties were served with the complaint, and we had a hearing live in court by Zoom on, the first date was March 1st. And I signed the order on that date. The defendant had until March 11th to vacate the premises. No one showed up for the hearing.
I was having a hard time with my phone.
Yeah, that's not our problem. That's your problem.
I know.
You have a right to come here and be here. Anyway, no one showed up. So a few days later, you got the order for default and you filed a motion to set aside the default. That was filed on March 11th, the 10th day. You explained in order to set aside a default, you have to have two things. You have to have a legitimate reason for not appearing, a good cause for failing to appear, and you have to have an indication that there is a meritorious defense. In your good cause for why you didn't show up, you said, I could not connect to Zoom on my phone and had to re-download Zoom. I called the courthouse, spoke to the clerk who helped advise me on what to do. So you filed this motion to set aside the default. As for meritorious defense, you indicate in 2017, we refinanced our mortgage. We signed a paper that stated in case one of us passing, the surviving spouse would be the sole owner of the mortgage, balance paid in full. We tried to get the mortgage current before the sheriff's sale, and they refused my payment. Well, the sheriff's sale was 180 days. The sheriff's sale was a long time ago, and 180 days passes from the sheriff's sale before they can have this hearing. So, Ms. Beamer, what's your response?
Yes, Your Honor. Just simply that under the court rule, we don't think that the two-pronged test is met. It's not a reasonable excuse for failure to log into Zoom under the first prong. And we've received, other than the statement in the motion, no other verified information or statement of facts that would establish a meritorious defense in this matter, and would ask that defendant's motion is denied.
Ms. Wilson, are you actually in the house?
Yes, I am.
Who else is there?
Just me right now. The kids moved out.
The sheriff's sale was a long time ago. Let me see what my notes say. And this is a long process that they have to go through to get this property back. This was filed in January. They served a notice to quit on you in December, and the redemption date expired as of November 11th. So the sheriff's sale was 6 months before November 11, which
May
had been
11th.
about May. And probably no payments had been made on the property for several years. And so people just are there waiting for bad news.
Well,
And
I tried,
I'm sorry, go ahead.
I did make payments for 2.5 years after my husband's passing. I figured that I could find the paperwork. I know that I feel like I've got nowhere with the bank after my husband passed away, I went to Farmers State Bank 3 different times. I went to 3 different branches. I tried to get a copy and was willing to pay $1 per page for all of the original documents because I could not find my page stating that fact that the remaining balance of the mortgage we paid in full. The loan was based on both of our incomes. Finances have just been really, really tight since he's gone. He bought leukemia for 13 years, and it was just a struggle. We've got 4 kids, which they've recently moved out. They're all 18 and up now, but I paid for the funeral myself. I've had 2 accidents since he passed. I've been struggling, and a lot of these are the reason I fell behind. There were, kind of circumstances beyond my control, and I have tried and tried my best, and this has been my home for 23 years, and I thought it was always going to be home, and I'm having a hard time. I've got 90,000 in equity. I feel like I wasn't really offered too many choices. I've read a lot about it, and I thought I should have been offered a loan remodification or something. I lost my main source of income. My husband was real sick towards the end, so my job was to stay at home and take care of him. I was a full-time caregiver. He was on a feeding tube and down to nothing. He literally needed help to stand, help to wipe, everything. So it's been a struggle, and then losing him, and I'm fighting depression. The kids all moved out, and my life has just been, I don't mean just to give a sad story, but yeah, I'm having a hard time.
Well, it's a very sad story, and I concede that,
It's not-
but your ship has sailed. As sad as this is, there was a foreclosure sale, a sheriff's sale in May. You had 180 days to redeem it, and you didn't do anything. So they started this
tried.
action. Then you didn't show up for the court hearing because you didn't prepare your Zoom until 2 minutes before the hearing. So we were here. In fact, we stalled around a little bit, hoping maybe somebody would show up, and no one did.
Well, I
They're
did
asking
actually
you to
speak with
move. They're asking you to move like today.
Get out the house.
You and all your stuff. You no longer own this house. The bank owns it. And you haven't made any payment on it probably in several years.
There you have it. See? This is everybody else. Who is that lady at the bottom? That's her. This is everybody else. This is going to be y'all. It's going to be y'all. That's why you're not. This is why your house is still going to be taken. Actually, you know what? Let me look at something right quick. What's the foreclosure? What's the foreclosure rate in 2025? What's the foreclosure rate? 367,460 properties recorded a foreclosure filing in 2025. Wow, that's 14% from Realtor.com. Foreclosure filings touch about 0.26% of U.S. housing units in 2025, up from 0.29, far below its crisis rate in 2010. So $367,460. Foreclosure, fourth quarter, 111,000, up 32%. December alone recorded 44,490 filings, up 57% year over year, and up 26% from November. Florida's ranking number 1. Good God. 8 straight months of increases. It's a trend. Y'all know what that means. Texas lead 37,000, up 14% for 2024. Look at that. Completed foreclosures, 46,000, up 27% from 2024. Look at this. Uh-oh. Uh-huh. Keep playing around.
So you're living in this house without making any payment. And so theoretically, the money that you would have to make the payment should be in a big pile in the bank, but it never is, because people use the money to buy groceries, pay the electric bill, make their car payment, pay their insurance. But you're living in this house that you don't own anymore, and you don't have the ability to redeem it. All the things that you're saying as part of your defense have all expired. And the bank is frustrated, and you are certainly frustrated, but you're moving to set aside the default. So the first question is, did you have a good reason for not appearing? The answer, in my judgment, is no. You couldn't get connected to Zoom. You didn't attempt to use the Zoom until 2 minutes before the hearing. You always had the
the night
option
before.
of coming to the court. So you didn't appear. In fact, I thought maybe you'd moved out. And then you did call later that day. The second question is, do you have a meritorious defense? And you said a bunch of things about how unfair you felt all this was, and the certainly very difficult circumstances that you were in. It isn't as though you willfully failed to pay your payments. Life came in harsh white light, and your husband's illness progressed. You lost his income, you lost your income, and you had a loan on the house that you couldn't pay, and they foreclosed on it. And that is a very sad but true story. I believe everything you're telling me, but none of it amounts to a defense to the fact that the bank is legally able to foreclose on the house. At least nothing that I heard. Ms.
They
Beamer,
wouldn't take payments in March.
I'm not sure what happened, but did you
I
ever
tried
talk to
make
a
up
lawyer?
Just legal aid. I thought I could find the paperwork. I just was hoping and praying that I could find it. I went to the bank and tried to get copies. But the bank was never able to produce all of the paperwork. They had a section of 6 pages at one time. Another time.
What is your defense in there? That somehow there was an insurance policy or something, and then
It was
one
part
of
of
the
the
parties.
mortgage. Yeah, I thought I was going to have all this money coming back where I'd continued to make payments after my husband passed away. So I thought
Well, I've never known of a mortgage that says if one party passes away, the mortgage is paid in full for the party that's left. I'm sure, I'm very doubtful that the mortgage has that as a condition in it. Are you aware of anything like that, Ms. Beamer?
No, Your Honor, and I know there had been communications between the bank and the defendant. The mortgage does not contain a clause like that, and no third-party coverage claim or insurance policy has ever been provided, nor funds for full payoff that would result in a claim against such a policy.
I thought if we didn't have 20% down, we had to have PMI insurance or something. I don't know if it was PMI insurance or Is it in the application that we did? Because I remember we were sitting in the bank with Faith Gardner. And she said that the loan was based on both of our incomes, and that kind of helps protect us so that if we do lose one of the incomes, they knew he was sick when we did all this. I don't know. I wish Chris was here because I don't know. I remember him talking to his boss about it and talking to my dad, and he had peace of mind knowing that me and the kids would always have home. And I don't know. Is there any possible way I could, I know I've missed the redemption period, but I have been working, trying to come up with money to pay it off.
Man, look, see, y'all see? What do you think would have happened if she'd have had valid legal claims? You see this? Now you got to beg to keep the house. Now you got to beg to keep the house. You don't have no money to keep it. Now you got to beg. See? These are the positions I'm telling people not to be in.
Is there any way the bank would work with me and give me the possibility of paying it off still? And you know, I've paid quite a bit on this place. I've worked my butt off.
I don't know the answer to that. As I said, there was a legal process. And they posted it on your house. There was a sheriff's sale here at the courthouse on May 11th. It told you had 180 days to redeem it. So after May 11th, I don't know what was done in March, but after May, you had a right to redeem the property. And that didn't happen.
Because it was $50,000. I didn't have it. But I did I did have enough to get my account current in March, and they refused my payment. And that was well before the sheriff's sale. And I had enough to pay all of the late fees and everything. So I thought I read that if I was current before the sheriff's sale would be canceled.
I don't know about that, but you never filed anything in the legal action. So now it's at the 11th hour and 59th minute and 59 seconds, and you're raising all these defenses that perhaps should have been raised a long time ago. I don't know if you understand the gravity of this. There was a sheriff's sale. You had 180 days to redeem it. You didn't redeem it. You didn't file anything. You didn't, I don't know.
I didn't think I could afford it.
All right, well, you can't afford it, and they want you to move out. They bought the house back. They own it.
Oh, the bank bought the house back. See, that's a toll. Woo! The bank bought their own house back. Lady, you don't have a leg to stand on. Listen, all these claims and stuff we talk about, that time has shipped and sailed. So basically, when they bought the house, that means her obligation has been satisfied. So now they're the owner. So now she has to move. There's not anything that she can say like, well, you violated this, and I looked on your books and I checked your SEC file. Those arguments are done because they brought the house back now. So her obligation is over with. Like when somebody buys your house at a sale, they own the house now. So even if she had claims, that ship has sunk. It's sailed and it's sunk.
And
So
you've been living
away
there for a long time without making any payment. They actually wanted you to move by yesterday.
Hold on. So all these 180 days have already passed, and you're just now coming. Oh my! What the hell is wrong with you're the last minute? No, courts don't work like that. No.
March 21st, or the sheriff would come put your stuff out in the street. You're very close to the eviction process where the sheriff comes and forcibly removes you from the house. So that's how serious this is. Ms. Beamer, she asked several questions that I couldn't answer. Does the bank have any interest at this point in trying to redeem this?
Respectfully, Your Honor, no. This has been, there was 3 prior foreclosures. I mean, like I said at the first hearing, there's a bit of a history here. While sympathetic to, the tragedy of the circumstances, unfortunately, the process has occurred, and they're not interested in any redemption at this
It's
point. We'll
because
just
of my
ask
husband
for,
having leukemia and us having.
That, ma'am, and I'm sympathetic too, contrary to popular belief. But ma'am, let me just tell you this. I couldn't even help you at this point. There's nothing I would be able to do. There's nothing I would, it's they now if the house hadn't already been sold and they actually brought the house back, I usually never really see banks buy the house back. That's personal. Like, they really want you out the house. Like, they like, you rarely ever see banks buy the own house back. Like, just sell it and get rid of it, fire sale. So by them buying the house back, that's personal. They want you out. That's all that is right here. They just want you out for whatever reason. I don't know why. I mean, she gave us reasons, financial hardships, and I get it. But I mean, they don't think you're going to pay. They don't think you have it to pay. You're so far upside down in it, ma'am. It would have been better for her. Like, y'all, every foreclosure does not need to take place. What you can do is you can sell your home. You can sell your home at minimum for what the bank wants. Yes, you may have to start over. Yes, you may have to downsize, but you got to do what you got to do and work yourself back up. But instead of, I tell everybody, if the last worst case, just sell your home. They will buy it from you and they'll know the situation. Yo, I got to lean on it. So at minimum, what I need you to do is pay off this remaining balance and like give me 10,000 relocation fees. Help me get into this apartment. For people that really want that house, you best believe they're going to do that. I know people that work in that business that buys, they are going to do that. Probably throw you 10,000 for you to move. They're going to get the U-Haul trucks for you and everything. They're going to do that. So you can always stage off a foreclosure by if you don't just sell the house.
4 kids and going clear to Detroit for his treatment. So yeah, we struggled, but we always got ahead. We always we recouped. We always figured it out. Usually it was me working 2 jobs while he was at home sick. I took care of the kids. I worked my butt off trying to get it recovered over and over again. I have 90,000 in equity. Well, I don't now, but so I just walk away with nothing.
And that's her biggest problem right there. That's the hardest part with her, because she had 90,000 in equity. And this is the thing this is the harsh realities about mortgage. Once you default or they foreclosure, you lose your equity. And people lose their equity not because they just lose it by matter of law. They lose their equity because they don't understand how to make those type of arguments to offset the equity. But even if, see, this is where SETU becomes important, because let's say she owed 300,000 right now. See, if she was with us, first thing we would do with our professional contacts, we would find out how much is it really worth. And once we found that out, we would transpose that against her equity she's already built up. And then we would put a rocket under their seat and send her straight to the moon. That's exactly how we would get down to business. Because the amount that they're kicking her out for is never the amount that they actually paid to take back possession of the home. Actually, which is sad for her, and I'm real sympathetic with her, is her loan balance has already been satisfied. I'll just say that. It's already been satisfied. But she doesn't understand the arguments to make those type of arguments to prove from a legal standpoint. Like, hold on now. You trying to double the I can prove how this was satisfied, which ties back to me satisfying this obligation. See, we can prove this in court. Matter of fact, Trisha, we gonna file as the plaintiff in federal court. Watch us work.
I wasn't offered any kind of loan modification or any. I don't understand why I couldn't have used some of my equity to, to help me get caught back up.
Right there. See, oh, you hit on it. That was pretty cool. But this is not the timing of this argument. It's gone. You waited too late. See, if you would have known the Supreme Elite, if you would have known me, we would have helped you out, given that if before the 180 days, like right when they was trying to put you out, we would, hold on, let's get to work. But yes, ma'am, you're going to lose that equity because you don't know how to present that in a legal, like it's so many things that you have to layer that claim in that you can't just be like, hey, I'm going to take my equity out. It's so many, it has to be coded into your argument.
Also had 2 car accidents. I paid for the funeral by myself. My in-laws, I could go on and on. Everything has just gone wrong. And I did try to come up with $50,000 during the redemption period, but that's a lot of money for me to come up with by myself in 6 months. But I tried. I have the ability to pay it now, but I know I'm past the dates. And
Well, I can't force them to enter into it. They've gone all these steps.
Hold on. You mean to tell me that you only owe 50,000? Oh my God, girl, come on. You should have. Hey, oh my, all you owe is 50,000? Man, your loan has you done satisfied your loan 10 times over. See, this is, and when we get to the mortgage side of SETU, this is when we having a special guest, the IT, Fannie Mae, Freddie Mac. You've already satisfied your mortgage 10 times over, and you don't even realize this is more than
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby. Folded thicker than a skyline. Credit acceptance on a resume with stories in the fine lines.
The investors they already got paid. You've already paid them all. This is just all, and this is how they use the contract to stick it to you after they've known they've already made money hand over fist. You've already paid it over hand over fist because once again, in SETU, you learn that, remember there's 5 different lenses to the contract. You'll learn the corporate side of the lens and you will blow your mind away. Many people think they actually owe because of what they're looking at the contract, but they don't know how to look at that one number and then look at the number from a corporate standpoint. See, that is the difference over here. That's and everything could be proven in court. Everything is proven in court. That's the difference. They'll look at that contract. It says, got the loan for $300,000. Now I owe $750 back. And they'll look at that $750. They'll look at the $750. But the finance company ain't looking at that $750. As a matter of fact, the finance company don't even see that $750. As a matter of fact, that number is nowhere in the equation when you get behind the scenes. That's what makes this system so vicious. But I got to get to this client. She is a girl. Worrisome now. This is a worrisome client here, boy. Woo. So worrisome client. I be having some worrisome ass clients now, boy. Woo. It's that crack, boy. They want that liquid crack. I got that crack over here. God damn it. But whatever the situation is, just know that, y'all, there's always a way. There's always a way, and there's always a legal way to do what you to do things. What you think is legal versus what
the legal way actually is, the only way you're going to understand what the legal way actually is you can't look at what the legal way is from your lens. You got to look at what is the legal way? How does it really work from their lens? Like you gotta work the leap from their lens. We gotta stop acting like we know it all. We gotta stop acting like we know it all. And we gotta stop acting like like it's a us against them system. We get that it's that to a certain degree, but you can't not just discredit what lawyers are saying. Or their bar side, like all lawyers are going to send you up the creek. Like we got to get out that mentality, because my own situation should prove that's wrong. I worked with their lawyer. There was no railroad going on with me. Like we cannot carry that mindset that you could just fight the system your own way. You have to fight them in their world by their rules. You can't be like, nah, there's only rules for corporations. They don't apply to me. Yes, they do apply to you too. Oh, them statutes and court rules, those are only for corporations. I'm not a corporation. I'm a living being. No, that won't get you nowhere. You're going to lose. But once again, I don't know what I'm talking about, but it seems like you never see me in positions how the other people are coming online. Y'all, look what they did to me, man. They did me dirty. I had them. See, they ain't want the truth out. You don't ever hear that come from me. You don't hear that come from me. It just works smooth. UWM right now got them running from the hill. Got them running for the hills. Got them running. Throwing their servicer right under the bus. See, if you're in my Supreme League team, you know that every time like I step into it, it's like they always get gang goofy on the other side. Oh, they get silent. Oh, they don't know what to do. That's when you know you're effective in what you do. But whatever the case may be, y'all figure it out. Most people are going to look at their contract. They think that like say in an auto, of which we're going over here, they think that the finance company actually, let's say the sticker price is $25,000. They actually think the finance company actually paid the dealership that $25,000 for them. They think that, but we all know what happens. Like they really believe that they're dishing out that type of. They're not dishing that out, man. It's pennies. This provide, like before you even. They even send you a default or notice of intent to sell your vehicle. Like, my gosh, but it's already happened on the books. My gosh, but this is where you see these people focusing on who has the right to
rocking with the best.
You're not the lien holder. You can't be doing this. Or they'll be like, if Carvana gave Century Auto the right to service and allow them to repossess, they'll be calling Century Auto like, hey, you're not the one I didn't get the loan from you. You never gave me any. Do y'all see what we're reading right here? Can y'all see how this makes a difference in our arguments? Can't y'all see how this makes a difference in our arguments? Like you wouldn't even care who's servicing the contract. It doesn't even matter. Because SETU, y'all, we get into the meat and potatoes. This is something that they don't want to disclose. And we know it. Now y'all can actually see what the finance charge actually consists of. You see that? These are the items, all the items of what's the finance charge. But see what they book it as? You see what they book it as? So when you look at your finance charge on your contract, and then you understand this and come here, you'll realize everything you paying in the finance charge ain't nothing but fees and stuff being passed on to you. The problem with many people out here, y'all, is they can't prove what the finance charge actually consists of. They don't know. Because they use these highly technical accounting terms. Let me look at that right here. And if you look here, this is how they're jacking up the price of the vehicle. You see that? Look, included in the principal balance. See? All that extra stuff, all those extra stuff that you're getting is being jacked and built into the purchase price of the vehicle. 50% of people's purchase price of their vehicles is all fees and behind the scenes stuff that they just passing on to you. But they can't pass it directly on to you because it will violate TILA. So how they get around TILA is they'll put all those fees in the purchase price of the vehicle. Now, can't get around it. That's how much the vehicle costs now. That's how they get around TILA. That's how they get around TILA. The only way you can stick them on a TILA claim is if you know this right here. Bam! Because none of this is disclosed on TILA. That's how you get them. This is how I got credit acceptance. Y'all got an inside view on how I stuck it to them. And notice how they had to settle. Where's it gonna say, this is not true. This is how you get them. When we get to the court side to SETU, this is how you get them in court. And you won't waste your time with these frivolous, who cares, doesn't matter type arguments that you see people make online all day, every day. Because with them, they don't understand that the consumer takes on this consumer contract takes on 5 different things, 5 different views of it. People think that the finance company views the contract just off the obligation that they owe. As we went over earlier, the finance company don't even view the contract based on the total of payments, the amount financed, and what you got to pay back. They don't even care about that. They don't care. They don't view it like that. Remember, you got the consumer side, which everybody views the contract. You got the court side, how the court views the contract. You got the corporate finance side, how they view the contract. Then you got the regulatory side, how they view the contract. Then you got the investor side, how they view the contract. If you don't know the corporate finance, regulatory, and investor side, you are going to put yourself at a deficit just trying to argue these contracts based on the consumer side. Knowing the other 4 actually puts you in a position to lead to settlements. They don't want to talk about it. They don't want to get into an argument with you over this when you got them dead to rights. You don't have them dead to rights by just keep trying to argue consumer. And this is why the SETU right now is so important, because y'all getting the other 4 views of the contracts, which they will never tell you. You will never know it's there. I can take one contract and explain it in 5 different ways, and which we're going to do in these classes. I'm going to break down the contract and explain to you what it means, 5 different views. Because unless you know all those 5 things, you're never going to fully understand your contract. And this is going to lead to frustration for a lot of people out there, because they think they're citing all the consumer laws, but the courts know they don't know the other side. The finance company knows they don't know the other side. And this is why they'll send in all these documents, but their vehicles are still being repossessed and their homes are still being foreclosed on, because they don't understand the game from a corporate professional level. And this is what SETU brings.
See the gavel and he ran, yeah. Thomas with that knowledge, calling Dr. Seuss. Yeah, I know what it is. They coming with these packages, secret accounts like they had a right to pursue that BS. Now, I know when that theory came from Roger Elvis, it was all a myth. Now look at them. So desperate, they like flies on. Every free money without understanding, and they jumped on it.
You're rocking with the best.
They fell for the okie doke. Now they don't want to admit they got taken to the bank because of their own desperation and greed. Facts. Now they want to hurry up and do another process to cover that. Embarrassment up? Nah, I see you. Can't pay your bills. Now you want to create instruments with nothing backing it. Think of that secret account.
You're rocking with the best.
Where the millions at? Where the mansions at? Where the assets at? Nowhere to be found, nowhere in sight, but y'all wanna get mad at me.
You're rocking with the best.
You winning. All self-taught professionals on my team, that's a fact. Y'all heard the phone calls. I played a major role in my own settlement, legendary.
You're rocking with the best.
Let me see the wet ink signature. And all that garbage, get your cars repossessed. And you wanna blame the system like it's a conspiracy. What they always say, oh yeah, and I want the truth out, nah, that ain't it. You just had no foundation, you're mentally lazy. And don't wanna accept the fact that you fell for the sovereign citizen trap. Come to SETU, we will deliver you.
You're rocking with the best.
The struggle processes. You won't have to tender a check just cause you can't afford or don't wanna pay a bill. You'll be like me. That like the way entitled back to you, friend.
You're rocking with the best.